mentioned for listing of the.
You're not properly attired.
Oh, I have to do this.
Yes.
Yeah, please. Lordship, I beg to mention listing of the case for press case.
Press matter.
Yes, sir.
Why is it not? Why do you have to mention? You'll come
It
with-
was filed on 5th of April, Lordship. Since then,
There must be some defects. That's why it is
No defect, Lordship. It has to be numbered, Lord. No defect.
no defect.
Yes.
একটু check করে লো কি লিস্ট করে বলবো হ্যাঁ yes I will লিস্ট করে দিই
May I please tell answer? WPC number 830622 last 19324 was opposite party obtained 2 weeks time. So we want to mention it early. 29 for
29 29
May I please your lordship? I beg to mention item 5. Lordship, the conducting counsel, Mr. R. Hazarika, has some personal difficulty. So kindly, we have taken the consent from the other side.
At the request of learned counsel for the petitioner, a request made on behalf of the learned counsel for the petitioner, matter stand adjourned for 2 weeks.
I apologize for my behavior.
Huh?
I have to do this for my.
Yes.
Lordship, this matter pertaining to a suspension matter. The petitioner was working
Fresh,
under
fresh matter, old matter, new
old
matter,
This old matter.
old matter.
Your Lordship, this matter has been approached before your Lordship twice, and on last occasion, your Lordship has given 3 weeks time, but thereafter it has not been listed.
When was it listed last?
28 to 2024.
Right, list on 6th of May. 6th May. Yes.
One notice has not been issued, madam.
Yes.
My lord, in this matter, my lord, item 1, my lord, I am appearing. In this matter, my grievance is that, my lord, my service has been regularized, my lord, in the year 2015. My lord, after that, my lord, in the year 2022, my appointment has been made to some, transferred to some school, my lord. After that, my lord, I have retired in the month of March, my lord, 2023. On retiring, my lord, the Block Elementary Education officer has communicated me to submit documents regarding NPS. But my grievance is that, my lord, I have joined in service in the year 1999. As such, I am entitled to the old pension scheme, my lord. My lord, as the authority,
There was an order asking you to file the what advertisement?
yes, my lord, in this regard, I have filed an additional affidavit, my lord. But thing is that, my lord, I have not able to get the advertisement, my lord. And therefore, I like to submit, my lord, before your lordship.
Where is your appointment order?
My lord, I have not given it. Oh, sorry, my lord, I have given. Sorry, my lord.
Appointment order.
My appointment order is at page 17, my lord, Annexure 1.
Yes.
My lord, subject to the termination without notice and without assigning any reason of Sri Abdul Halim is hereby appointed with effect from the date of his her joining as assistant teacher in scale of pay so and so, my lord, plus other allowances as admissible under the rule in Khagrabari Orunodoy ME School against the sanction post by the Government of Assam sanction letter by numbers 24/4/1998 and EE is communicate letter number dated 27th of November 1998. The appointment is made as per approval of the Sub-Divisional Advisory Board BAC Nalbari. The expenditure will be debitable under the head of return to instrument.
Yes. Then
Yes, my lord. After that, my lord, my post was converted into non-plan scheme, my lord. My lord,
how was this was it pursuant to a selection process?
yes, my lord. My lord, what happened, my lord, in the year 1998, advertisement was issued for the
This
whole
was-
Assam, my lord.
This was for OBB.
OBB, yes, your lordship. OBB. My lord, regarding regularization, my lord, it has been placed before the division bench, my lord, by the respondents, my lord, and finalized the position, my lord. Therefore, my lord, I think my humble submission that the appointment, advertisement of the appointment may not be necessary, my lord. My lord, the division bench judgment, copy of the
No,
judgment, I have it
after that, your appointment was terminated.
in the year 2009, my lord. Till then, I was getting my salaries
Uh,
in full, my lord.
Then.
After that, in the year 2015,
Uh.
my termination was withdrawn, my lord. I have annexed it at page 26, annexure 5, my lord.
Hmm.
Here it mentioned in the order that in pursuance of the Borderland Territorial Council Executive Meeting Resolution number 4.1 dated 27/4/2015 and resolution number 4 in the minutes of the departmental meeting of Education Department held on 26th of June 2015 respectively, the Borderland Territorial Council is pleased to withdraw the termination order issued by dated 3/12/2008 against Abdul Halim, Assistant Teacher, Khagrabari, Arunoday M School in terms of Director of Elementary Education Assam order by dated 14/11/2006 with retrospective effect.
Then you are regularized in 2015.
Yes, elective. Again, another order issued in the year 2022, my lord, 14 July 2022. It mentioned that in exercise of power conferred upon the Director of Education BTC Kokrajhar, Vice Secretary BTC, letter number 13 September 2005, and in pursuance of approval of BTC, Vice number 20 dated 14th of July 2022, and Gov of Assam communicated by number 20 dated 9/2/2021, the service of Abdul Halim, Science Teacher, Khagrabari Arundoy High School, who has reinstated in service by order memo number 1st of October 2015, issued from this end, is hereby regularized as Science Teacher Vice Narendra Sandarnath, BSc Teacher, and posted a Betna Bepeli Milan in the full scale of pay, 20 Melo plus grade pay, 8,700, and other allowances administered in the government rules, my lord. Subsequently, my lord,
Yes.
I was posted in Samandar School, my lord. Abdul Halim, Chandra Mohan Muhammad, San Muhammad, an inhabitant of village Banbaria, Hela, District Bavada, is assistant teacher in Khagrabari Arunoday High School. He has been appointed as regular teacher in Betna, Defeli, Milan, ME School. And in pursuance of approval by the 14th July 2022, he has been released from Khagrabari Arunoday High School on 16/7/22. This is for favor of your information and necessary action. Later on, my lord, the authority has taken an undertaking, my lord, from me, my lord, wherein it is mentioned that, my lord, I have annexed it as annexure 10 at page 35. I understand and accept the government servants joining the service in the state government on or after 1/2/2005 shall not be covered by the existing Assam Service Pension Rule 1969 and order issued thereunder from time to time, and that the pension and other retirement benefit will be governed by a set of new pension rules which are being formulated with the contributory pension scheme of government of India going to be notified in due course, my lord.
So what is wrong about it?
My lord, in this undertaking said that who has appointed after 1/2/2005, my lord, but I have joined in service in the year 1999, my lord. As I am,
But then you were terminated subsequently.
my lord,
And
The-
your regularization was not with effect from 99.
my lord, retrospective effect.
Where? Let us see. 2015 is your regularization order.
Yes, my lord. My lord, at page 26, my lord. Last line, my lord, it is mentioned, dated against Abdul Halim, Assistant Teacher, Khagrabari, Anodoi ME School, in terms of Director of Elementary Education, Assam, order number so dated 14/11/2006, which,
You are reading from which page?
sorry, my lord, it is prospective effect.
Prospective effect.
But my lord, yes, my lord, my contention is that, my lord, regularization. Regularization does not mean permanency, my lord. Regularization means whatever the irregular is regularized, my lord. It has been held by the Supreme Court long back, my lord.
No,
My
no,
lord-
your claim is that you are in service well during the currency of the earlier pension scheme.
Yes, my lord.
So therefore, you are entitled to the old pension scheme, not the new pension scheme.
Yes, your lordship.
But the facts are like this, that you were terminated and subsequently you were again termination withdrawn, but you are regularized with effect from 2015.
My lord, that's why I am submitting regularization. What have been regularized? My appointment has been regularized.
From
If-
which date?
My lord,
From which date?
my lord, my service was regularized. Here mentioned that prospective. But thing is that, my lord, what has been regularized? My appointment.
Then-
My appointment was long
Have you-
back in
have
the
you-
year
have you-
99.
Have you challenged this regularization? You have
Well,
not challenged this regularization.
Yes, my lord, I have not
Then?
challenged that regularization. But thing is that, my lord, the interpretation of
No,
term
interpretation is
regularization, my
not
lord.
called for. That is why we are asking you. Unless
Yes.
you put it to challenge, where is the scope for interpretation?
My lord,
You have accepted it, your work.
my lord, my humble submission is that regulation cannot be a
Your
way of
argu-
appointment, my lord.
we are not ready to accept your arguments here because
Yes, my lord.
this regularization order is not put to challenge. You have accepted this in 2015 and you have come before this court when? 23.
Yes, my lord.
Then?
23, my lord. Before that, my lord, I had another order. My service has been again regularized, my lord. That's why, my lord. These two order, my lord.
No, regularized, that subsequent order is regularization in respect of some other school.
Yes, my lord.
Your regularization is normally with regard to one particular school. So for some reason you were transferred and posted in some other school, in some vacancy which arose because of death or retirement. So there
Maybe,
you are
my lord.
again regularized in that
Yes, your
stream.
lord.
But assuming that is a continuation of the earlier order, your first regularization is in 2015, which
Yes,
is
my lord.
after the new pension scheme.
My lord, regularization is that, my lord.
Yeah.
But thing is that, my lord, regularization means regularize my initial appointment, my lord.
Mm.
If
No.
initial appointment, then it is in the year
Your
99.
initial appointment, nothing is mentioned here.
My lord, as
Nothing is
apex
mentioned
court held, my lord, regulation cannot be a way of appointment.
Then we'll have to hold that this is no appointment. But then you are not challenging this.
If it's so, my lord, that is correct, my lord. If it's so, otherwise, if regularized, my lord,
No, we are not.
hereby my termination order has been withdrawn, my lord.
Okay, all right.
If withdrawn, then what is the meaning of prospective, my lord?
All right. Yes. Respondents, what do you say?
He is keeping many things, my lord. First of all, the termination, first of all, this appointment was illegal. And the series of cases were filed.
Whatever it may be, subsequently it was withdrawn, he was regular.
It was not withdrawn, my lord, like a defined manner.
No.
But if termination was there, they have challenged the termination.
No. Read page
My lord,
27.
that withdrawn. The fact is that another writ appeal he has missed it, my lord. Why it was withdrawn? That's a policy decision, it was withdrawn.
Whatever it may be, it was withdrawn.
Thereafter, the policy decision, my lord,
Huh.
it was taken up that 2015 that order was passed to regularize him in a prospective manner in 2015. So regularization has come with effect from prospective manner 2015 on 1st October 2015. So that new pension scheme will come, old pensioners cannot come into it. Because all the appointment in 2019 were challenged, they were terminated, these were upheld. Thereafter, the writ appeal was filed. In the writ appeal, the British chair decided that the policy decision will be taken to take up this matter. The person who have got the salary in a particular day. Thereafter, the policy on the basis of the policy decision, they were taken back in service. The termination order was withdrawn and taken back in service. Thereafter, subsequently, they have joined. And in a policy decision, when they have joined it, they cannot turn back and say that this is wrong. And since they accepted it, And in this regard, I will cite a decision, my lord, of the apex court, exactly identical in situation, my lord.
Yes.
But she will- Here also exactly when on policy decision, illegal appointment was made. Thereafter, the policy decision, they were taken back. And paragraph number 11 and 14, my lord.
11 and 14.
14, 2015, 14 SCC, 382. Where it first paragraph number 11.
Yes.
And on the outset, it is to be pointed out that when the vacancies of the post of assistant manager civil were advertised on 2011-2022, the scheme of regulation of the contractual employee were not involved, and it is only subsequently on 16/4/2003, respondent one has taken a policy decision regarding the regulation of 27 contractual employee, and the scheme approved by the state government by letter dated so and so on. It is only thereafter the applicant came to the appointment on 6/8/2010. Thus, when the vacancies are initially advertised, the appellant did not have the substantive right against the notified vacancy, and the appellant cannot say that they have acquired the right to regularize by virtue of the decision of the single judge so and so, and held that and should not issue a direction to the regulation unless the recruitment itself has made a harm of the constitutional scheme and the wide power of Article 226, and not indicate to be used as a issue for such direction for regulation. The appellant were actually regularized only by virtue of policy decision taken up by respondent number one and not by virtue of any decision of the High Court. So she will now turn to paragraph number 14.
Yes.
The appellant were initially engaged in the contractual basis and they were not appointed against a substantive post before they were subsequently appointed on the said post on 6/8/2010. Even though the advertisement dated 10/11/2002 indicate that there were vacancies, the policy of regulation of contractual employment were approved by the state government only on 5/3/2008. The appellants were appointed on the post for the assistant manager only pursuant to policy decision of the respondent for regulation of the contractual employee, and thus the appellant cannot ask for regulation of the with respective effect from 2011-2002 that in where the advertisement were issued. Because of the time of regulation, policy was not informed. The policy of the regulation, it was indicated in the given in the benefit only from the date of appointment. The court cannot read anything into the policy decision, and the plan were ambiguous. Having accepted the appointment order dated 6/8/2010 and also joined the post, the appellant cannot turn around and claim regulation with retrospective effect. Now it's a identical situation. The policy decision has been taken by the BTC authority to regularize, and regulation were done prospectively. Now they cannot turn back and this after accepting it, they cannot turn back. Otherwise, they could have challenged this decision, that appointment of retrospective effect.
My lord, in this regard, my lord, death judgment may not cover my case, my lord, because, my lord, they are holding some non-substantive post, my lord, but I was against sanction post, my lord, since 99.
Yes. Yes. What do you say?
My submission is regarding that judgment, my lord. That judgment may not cover my case, my lord.
So it is only about the question of the date on which you are regularized. You may have been working on contractual basis, temporary, whatever it may be. There was a termination. Subsequently, it was withdrawn. You are
My lord, my submission is that, my lord, by withdrawing.
What is this?
It is regarding their termination. They were terminated, and this termination order was passed in a series of cases. They were termination was appealed. These cases were dismissed. Then the appeal went. They preferred an appeal. Appeal in the policy decision was taken. They will be.
All right.
My lord, as the authority passed the order withdrawing my termination, my service has been continued. Because they have withdrawn, not mention only that regularized or appointed me, my lord.
Claim for pension will arise from the date you are regularized, you are officially regularized post, sanction post, having the benefit of pension. You may have been working, you may have been rendering services, but you are not regularized.
My
You
lord,
regularized earlier. Prior to termination, were you regularized?
my lord, in this regard, I have to go through some laws, my lord. My lord, kindly allow me some time, my lord.
We have heard. We have heard.
Yes, my lord, but
If you wanted time,
keep
you
it,
should
my
have
lord,
prayed for
pending.
time.
Keep it, my lord, part heart, my
If
lord.
you no part hard business. If you wanted time, you should have prayed for time. Once the matter has proceeded for hearing, where is the scope for now adjourning the matter and keeping it part hard?
My lord, in this regard, my lord, my submission is that, my lord, the authority has withdrawn my termination order, whereby my service has been continued since earlier initial appointment, my lord.
Yes.
As continued, I have joined in at the stage of initial stage in the year 1999, my lord. 4th of December 1999.
Yes.
In this regard, my lord, regarding regularization, I want to draw attention to a judgment of the Apex Court, my lord, that is cited 1979 for SCC 507, my lord. At paragraph 24, it is stated, my lord, in
You
Nanjun.
give a list of books. You can't just take out a book and argue. We also have to call for the book. Do you have a copy?
Sorry, my lord, I have not provided.
Then what is the citation?
Citation is, my lord, 1979 for SCC 507.
What is the party name?
Party names are B.N. Nagarajan and others versus State of Karnataka and others.
Yes. Which paragraph?
Paragraph 24. Paragraph 24, my lord. In Nanjun Dappa case, also the question of regulation of an appointment arose and this court dealt with it. Does counsel on behalf of the respondent contended that regularization would mean conferring the quality of performance on the appointment, whereas counsel on behalf of the state contended that regularization did not mean permanence, but that it was a case of regularization of the rules under Article 309. Both the contentions are fallacious. If the appointment itself is in infraction of the rules, or if it is in violation of the provisions of the Constitution, illegality cannot be regularized. Ratification or regularization is possible of an act which is within the power and province of the authority, but there has been some non-compliance with procedure or manner which does not go to the root of the appointment. Regularization cannot be said to be a mode of recruitment. To accede to such a proposition would be to introduce a new head of appointment in defiance of rules, or it may have the effect of setting at not the rules.
It goes against you.
No, my lord.
Position is against you.
No, my lord. If it may go against me if the regulation is under challenge, my lord. I have not challenged the regulation, my lord.
Okay, anything else? Yes.
That is my case, my lord.
Okay. And you are appearing in all the matters. Okay?
Only one matter, my lord. Item one.
One matter. Who's for the other matters?
I am two, my lord, I am in two, my lord, second item that is different, my lord, but my learned friend, my lord, is stacked together, it should be segregated because, and in my case, notice of motion issued earlier.
Item.
আৰু এটা file মোৰ তলত Well, earlier, my lord, that the BTC matter, my lord, that all the personage regularized in 2015, my lord, and thereafter, in my case, I am converted to the
Yes.
tutor, my lord, in existence of earlier regularization order. That my earlier regularization order is at page 36, annexure 1. In our case, my lord, not only regularization, it was reinstated. Reinstated means reinstated to the earlier post where he was initially appointed.
Take us through your case properly. You are appointed as what?
Well, I am appointed as the teacher, my lord. LP school teacher, annexure A, my lord. Page 19.
Yes. You are appointed in a temporary post. Temporary.
Yes, my lord.
Okay. Then
My lord, that regarding that, the series of cases that earlier your lordship has taken, my lord, thereafter the writ appeal.
no.
Thereafter, my lord, that
You were
I was terminated.
You were terminated.
Terminated.
So that was checked.
Thereafter the series of case and thereafter writ appeal, that's a review. And thereafter the order dated, my lord, 1st of October 15 at page 36.
Yes.
Thereafter, my lord, the last page at page 39, my lord.
No, wait. So after annexure A, then what happened? You joined, you were terminated.
Yes, my lord.
Then writ petition filed, it was dismissed.
Yes, my lord.
Then writ appeal during pendency, policy decision taken.
Policy decision.
Then what happened?
Then that thereafter regularized.
Regular.
Reinstate, my lord. Regularized oblique reinstated.
Where is that order?
Page 36, my lord. Next 1.
36. 36.
Annexure I, my lord.
Annexure H.
Annexure I, page 36.
My one is 37, man.
In our copy, it is 37.
Same identical order. Earlier one.
Same order, my lord. All in all cases, same order, my lord. That, but here order is, my lord, is peculiar, regularized oblique reinstated withdrawing the termination order. The once a person is reinstated to his earlier post, my lord, is a different matter.
Earlier post,
My lord,
you are
that
assuming
what happened? I have no objection, my lord, that I am not claiming, my lord, other benefit also. But what happened the last order, my lord, page 39, my lord, last order, that converted to the tutor, my lord, in existence of that earlier regularization order, my lord, without any notice thereon.
You are not for pension. This-
I am not praying for. My prayer is, my lord, that earlier regularization order should be continued. Because their last order were converted, a person is converted
This
from
is
a
not
regular
for
post
pension, Mr.
Well,
Bora.
on
This is
or
not pension.
This is
two
not for
to
pension.
Lordship will turn to the payer portion.
my lord,
Ah.
1 minute. My lord, on my lord, earlier order dated 2 to 24, my lord, that two, three occasion, my lord, learned friend short time for filing affidavit. And on that date, invariably he is directed to file affidavit.
Prayer is for release of current as well as area salary
Yes.
with effect from date of regularization, not for pension.
Not for pension, my lord. So let the order, a case, my lord, be segregated with, because that is the regarding
But
Operation Blackboard case. This is different.
you are converted to a tutor. How does it affect you? Affect your service?
My lord, that the scale is different, my lord.
Is it lower scale?
Yes, my lord. The tutor is different thing and a regularized post is a different thing.
No. Tutor scale is lower.
My lord, how both the order will continue at a time.
No. I am asking you a question. You give me a reply,
Sure,
yes
sure.
or no. The tutor scale is lower or higher or similar at the same rate.
Lower, my lord. Lower.
Mr. Bora?
Okay, I have to examine this. Let this case be segregated.
File
and
affidavit, my lord.
I'll file my affidavit.
May be segregated because
Okay.
this is obese.
And what is item 3?
Identity pension. Lord.
This is pension.
Not pension, area salary also.
Pen-
Person joined with me, registered with me, they have been given continuous service, but I have been given less.
Let us have item 3. Okay, item 2, we write, you get your instructions here and
Not-
file affidavit. Item 2, we segregate.
May I pray for segregate, my lord, because this is a
Segregate.
We are
Operation
passing in
Blackboard.
order, kindly hold on. Item 2, upon hearing the learned counsels for the party, this matter be segregated,
Unnecessarily, he is tagged all the matters.
segregated from item number 1 and 3. And as this matter does not relate to pension. So, the grievance of the petitioner is that although he was reinstated, although he was regularized in the post of assistant teacher
Yes, sir.
in Suban Khata Sundari LP school by order dated 1st of October 2015. Subsequently, the petitioner was appointed on a purely temporary basis as a tutor in Bilpar LPS school in the district of Paksa. So, it is submitted that where the petitioner was regularized as an assistant teacher, there was no scope for changing the nature of his appointment from assistant teacher to that of tutor, that too without putting the petitioner to notice. Under such circumstances, the present writ petitioner has filed the writ petition praying for appropriate order. Mr. S. Bora, learned standing counsel. You are for PTC, Mr. Bora?
Lordship.
Well, that is for all the respondents.
No, Lordship, I am for 1 and 3, Lord.
Mr. P. N. Sharma, appearing for respondent 1 and 3. Mr. S. Bora, appearing for the other respondent.
PTC.
As PTC. PTC respondents submits that they would like to complete their work. According to matter dates. Matter be listed after
3 weeks.
3 weeks. Complete their research. Where is item number 3?
Obliged. I am sorry for indulging at the time of dictating.
No. Yes, item 3.
This case relating to, my lord, the petitioner was appointed in the year 99. Thereafter, he was continuing, he got the certificate also, my lord, that basic training course pass certificate. And their services.
Your prayer is also to get the benefit of
Pension.
pension.
Yes, sir.
Where is your appointment order?
That is, my lord, at page 15.
15. Then you were terminated.
Stipendary teacher, yes, my lord.
Then-
Stipendary teacher, they were continuing. Thereafter, my lord, around 200 teachers were terminated in the year, my lord. Mm, 12, my lord. Termination order is at my lord, page 36.
Then
Page 36. Thereafter, all the persons, my lord, including the petitioner, they have approached this honorable court. And by that time, my lord, the division bench order was passed, my lord, regarding policy decision and taken yeah, and instead the petitioner. So here High Court order is at page 42 and relevant paragraph is at my lord, page 46. I'm reading from page 45, my lord, that last paragraph. It is seen that the petitioners are similarly situated as in the case of the appellants in the branch of writ appeals and as the case of the petitioners in WPC. Having regard to the above, this writ petition stands disposed of by holding that the petitioners herein are entitled to the same benefits flowing out of the order that so and so passed in writ appeal number so and so. It is however clarified that while making necessary exercise for effecting regulation of their services, the Education Department so and so would verify the case of the petitioners and reach a conclusion as to whether they were regularly receiving salary from 2006. In present case, my lord, he received up to 2008, my lord. In the event they had received salary up to the said period and had been serving in respective schools at the jurisdiction of Boroland Territorial Council, their services be accordingly regularized with the effect finding direction discipline. Thereafter, my lord, page 47, my lord, all similar persons, my lord, who were similarly appointed and my lord reinstated. His reinstated order is something else. That in pursuance of the Honorable Guwahati High Court so and so, which is so and so, Sri Binoy Sahoria, S10 disabled, who was terminated by the Assam so and so, is hereby instated in the same service and adjusted against the sanctioned second post in the same school of so and so, retired. Also shall not entitle back wages. Another person also, my lord. So many persons, my lord, except me and few others, they have been given fresh appointment. And but his, my lord, if we impugn order is at my lord, page 49. But illegally he has been given, my lord, fresh appointment instead of my lord, communicated so and so, subject satisfactory police declaration, report on so and so, 99 to 12, my lord, 99 to 12, 13 years he has worked, thereafter police vacation, everything, will pay amendment so and so, Odalguri with prospective effect from 1/11/2020. The appointment is purely temporary and liable to be terminated so and so, and any kind of fraudulence regarding so and so. So all these conditions were given, my lord. That is the illegality committed by the warden.
But is this order under challenge?
No.
Yes, my lord.
Huh?
I have challenged this order.
In your prayer, it is not
No, not
reflected.
there.
Prayer is there.
If he challenges his appointment goes, he will be all.
No, my lord. I have asked that my lord continuation of service to issue directing the respondent any order should not be issued directing respondent press order allowing the petitioner to continuation of service along with all consequential service benefits to modify the order. Yes, my lord. If I cannot ask for cancellation of the order, but I have asked for modify the order. To modify the order that so issued by the director of Boland, that is the sentence.
No, but that is keeping in view your claim for arrear salary. Is that what?
Area salary is different part, my lord,
Then-
because the code has given up to 20,
Why do you want
2006.
why
but
do you want modification? Why do you want modification of the order?
Modification, my lord, it should be continuous like the other order, my lord. I have read along with this, my lord, our other colleagues who joined together, terminated together, reinstated, but reinstated order is there, different, mine is different.
But then
And
you
salary
have-
also,
you have
he
to
received
challenge
salary,
this
my
order.
lord.
This order is not specifically challenged.
Challenge means they have been reinstated me, my lord. I cannot ask for cancellation of the order.
No, not
I have asked
necessary.
for modification of the order.
For what purpose?
Purpose order is, I have written here, modify the order, otherwise you will not get giving the benefit of pension under old pension policy since his date.
When was the old
submission.
pension? When was the old pension policy?
Because 99, he is working since 99. Others are given continuations of service.
When were you terminated?
2012. But he received my lord salary, not to see the paid area salary since 1/7/2008. That means he up to June 2008 he received salary, man, not 6. Others, my lord, Honorable Court has ordered who has received salary till 2006. But my lord, I have received salary till 2008. I am not paid from 2008 to 2012. Something is different.
What is the meaning of this order? This 2019 and 22 order? 19, she is reinstated. Person is reinstated.
Well,
The order, the word is not regularized, reinstated.
Lordship, about 40, is now 49, Lordship.
47.
47 is a different set of persons. There is a
Yes,
different
but
set
they
of order.
appointed by the same order, terminated by the
that-
same order.
There are different set of persons. There is a different order.
So
So
not,
they are
not,
treated
not,
differently.
not for the petitioner.
Not for the petitioner. Lordship will come to the High Court order. Page number 42, where the petitioner is the current petitioner is the petitioner number 3.
What was the direction here?
I have
That
to
is the
submit
rate
some
appeal number
document.
182. They say the rate appeal number covers 182 of 2013 covers it. And the same order is given as the policy decision that covers their entire service. So thereafter, then the policy decision they were inserted.
No,
And their rate
you
appeal
are
order has been quoted.
referring to order
Yes,
811
my lord, for the beginning.
2019. 811,
Which Raman?
page
High
number
Court order.
44.
High Court order.
High Court order.
High Court order, page 42 onwards, my lord.
Yes, effective part is 44 onward.
Yes, my lord.
They say they have covered by the rate appeal order.
45.
This rate appeal order, entire rate appeal order is quoted. And thereafter, the policy decision they're taken back.
No, the rate appeal is not reflected.
Yes, my lord. In the middle, my lord, they have in page number 45, rate appeal number 182 of 2003. They say the division bench covers it. They are fancier. They came after the division bench order. They say that
Page number 44,
thereafter
Yes, my lord.
the order begins at 44, isn't it?
Yes,
Lord.
order begins at
8/11/2019.
Hmm.
So in the third paragraph, it is said that can be disposed of in terms of order dated so and so, passing WPC so and so.
Yes.
Not rate appeal.
no, thereafter, my lord.
Writ petition, this is a writ petition,
Writ
single
petition.
judge order. Yes.
2168.
Since the facts are covered by the writ appeal, my lord, that's why, my lord, writ petition is disposed of on that line of the revision bench order.
Okay, so it was disposed of.
Based on rate appeal level.
A rate appeal is mentioned here
Yes,
in,
it should be
in page
mentioned.
In the
45.
judgment, it is mentioned.
That writ petition which was relied upon had referred to the order of the writ appeal.
Yes, my lord. 2163, my lord. This is the order.
এইটা তো কোনো dispute এর কারণ নেই।
Your appointment is in a supernumerary post.
Type
Your-
in addition.
but
Initially.
in a supernumerary post.
Yes.
Kindly see the line below the table. The teacher is accommodated as a teacher purely personal in nature.
Yes, my lord. Initially, all the appointments,
Hmm.
200 appointments, all were like this only, my lord. Type in addition. Initially, they were appointed on 1800 only as stipend edition. Thereafter, they have passed the basic training course, and thereafter, my lord, they have been, my lord, scale was given, Annexure 7, page 31.
And what is the stand of the department here?
Annexure 7, page 31. The following incumbents are hereby allowed to draw the time scale of so-and-so plan other allowances as admissible under rule effect so-and-so after their names have passed their junior basic training
Where is the
examination.
writ appeal order? The writ appeal order is available somewhere?
Yes, ma'am, it is written.
Lords will take up my additional affidavit
Additional
filed on 23, 2024.
Yeah.
You will find the original.
writ appeal 182.
Yes, Lordship. Page number 63 onwards. Running page number 63 onwards.
Please read the order.
Are the appellant and the respondent. A policy decision taken by the board of University is received on call. The appellant were teachers appointed and working on various MA and MBA schools in the Board Territory Constitution. It is the case of the appellant that the appellant were appointed in the year 1999 and earlier. The appointment as teachers came to the terminated as being illegal, and the appointment order issued by the district elementary education block elementary district on Nobody were illegal. Therefore, the termination order issued by the district elementary PTC, this court application number 7 so patch and found that the termination order are illegal and demanded the metro to follow the principle of mutual justice that elementary rendered the exercise and again terminated for the for the school and time being the same reason. Agreed by the said order, the appellant were filing the writ petition. The learning single judge has found that the order of the appointment has been issued illegally and the order of the termination of is legal, and the dismiss the writ petition agreed by the said order. The appellant filed a writ appeal. It is submitted to the council to the appellant that the appellants were receiving salary up to 17th in 2006, and thereafter the termination was effective. The BTC as well as the government of Assam took a decision to regularize all these teachers who were in service are regular receiving salary up to 17th in 2006. In the first phase, the exercise it submitted that 221 teachers were found to be uh, eligible for the regulation as per the above law. It is the conclusion of the appellant that the appellants were also similarly placed and they should also be receiving the similar treatment. The council for the BTC submitted that the policy decision is taken for the person receiving the regular salary for the month of March 2006 would be regularized and the implementation of the policy in process. The government of Assam also agreed to the same policy. In view of the submission made, it will dispose of the direction to the respondent to respect regulation as per policy decision of the all these eligible teachers who were regularized receiving salary up to 17/10/2006.
Then at page number 70.
Page number 7. Page number 70 is a different set of order that was examined, Malo. And it is order that is order dated 28/11/2017 passed in WPC number 59 of 2013. That is Binoy Soye and others. Different set of person. So they were examined and they were treated different. Not this policy decision part. They don't come under the policy decision.
Why is it different? Why this order is different from the present petitioners?
Let me hand over the. Possible, I'm handing over the order passed by the in petition number 59 of 2013.
No, you tell us from the order. It must
But
be
it's
secretary.
completely different. It was examined.
Ah,
It was examined by the PTC authority, my lord. Thereafter, it is passed the speaking order, my lord. This particular order, my lord. That these are different person and they have been few other person. Then they were given the appointment, my lord. Not in respect. This is not covered by the under writ appeal number 128 of 2013.
no, what was examined? What we want to know. It's a long order. So there was some select list.
There's some different. This is from the reports were called, and after examining the reports, my lord, if lordship turn to page number 77, last two paragraphs, my lord. This is from Mongoldo area, my lord. Therefore, on the basis of the reports so submitted by the Director of Education BTC and the Deputy Inspector of Mongoldo, discussion here about directed that the cell was set up to instate the present petitioner in service after verifying their post, and they were left with the terminated on the service and the respective schools, and being fully satisfied with this regard, petition may be instated in their respective school in the last working day prior to their termination. They were given current salary and they are completely different set of with petition, different set of exercise has been taken, madam.
They are agreed by the fact that they were not reinstated.
They were they come on the policy decision. The policy decision has been taken. They themselves has come to the court and said they go under writ appeal number 182, 2013.
No, that's right. But they say that as like the earlier writ petitioners, they were not reinstated. Page number 47.
Yes,
Like some other person.
There are some other set of orders of the court. They are entertained in a different manner. They don't cover under the come under the policy decision. Those other
59. Okay. Yes, madam. 59 is a writ petition where there was some select list.
59.
The page number 47 of your writ petition. Writ petition, page number 47, annexure 13.
47, yes, ma'am. Yes, my lord.
Annexure.
Why I have annexed, my lord? For two reasons. One, your lordship will come to first, my lord. These persons.
No, you wanted similar orders like annexure 47.
Exactly, ma'am.
Now, annexure 47 has been passed in terms of the direction in writ petition 59.
Yes. But my lord,
petition
these persons were appointed together, terminated
Maybe,
together.
but writ
Their
petition,
statement, my lord, just
writ petition
same,
59.
maybe not same writ petition, but language is same. They are getting
No,
benefit from the writ appeal only.
No, writ petition 59 has issues with regard to select list and sanction post.
No, my lord. The original, my lord, order is, my lord, the division bench order.
Hmm.
In persons of the division order, following the division bench order, my lord, these persons were reinstated.
No. 59, there was a further direction to examine.
Whether my lord, 59.
You come to page number 70, which is
No, before that,
annexure.
I want to place, my lord. Page 31, your lordship, may kindly say, page 31.
Hmm.
They passed the junior basic training examination together with all these persons.
No,
my
then
lord.
you have to put, then you have to challenge this order.
Which order, my lord?
This order of reinstate.
That's why I am praying for modification. I cannot ask for cancellation or cost of the set aside of
right, but modification is not permissible here unless you show. How can there be a modification?
Let me place the fact. If your lordship is satisfied. First, my lord, that they were appointed in the same by similar, same date order. Thereafter, my lord, they have passed the basic training course. Thereafter, also the scale was given by the same order. That so and so. My name is at serial number 3. This Procedural, Dijan Sharma, all these are same date they have been given scale. And again, my lord, the deputation of the inquiry report, the director of Sabha, thereby terminated with the big ground. Termination order is also, my lord, same order. And the reinstatement, my lord, they have approached the court, and the honorable court has, my lord, following the division bench order passed in 2168, has directed for regulation. Yes. Now, my lord, your lordship is talking about some other numbers are here.
I am not talking, the order reflects. The order reflects that this is in terms of some earlier writ other writ petition,
Under the petition, my lord,
WPC 59. And in terms of
59
that,
of
in terms
59
of
of
that,
2013.
yes, in
Yes.
terms of that direction, passed in WPC 59, a separate order was passed, which is available at page number 70,
That is,
annexure 2.
it is after that. Yes, it after that. Court order passed. I forgot that order also, my lord.
That order is there
59
in the additional affidavit,
additional application.
annexure 2.
The court has got language maybe a little bit different. 59 order to application, no? One, it, two. Order? Huh? 59 of court. But where is the High Court order, my lord? This is the order by the government.
In this
This is
order
the
of the
order of
in the
government.
order of the government, you will find a reference to the High Court order. Writ Appeal
That-
59.
15. That in view of the above, the repetition is disposed of light of the observation made here with the direction upon the material to examine the case of the repetitioner after against will bear in mind accounts for remand instead of service and shall extend similar consideration in case of remaining repetitions as well, depending on the
You are
outcome
now
of
reading
such-
the order.
Huh?
You are now reading the order in court.
Oh, my lord, I have done so, but this order is, my lord, my order is different,
So,
this order is different.
different, yes, that's right. So it is in pursuance to this order that
Order- yeah.
the order that you are referring to
Yes,
of reinstatement
reinstatement.
was passed.
Yes.
In
Language
your
will
case,
little bit different, my lord. Language may be court to court, person to person, language is different. That does not mean, my lord, there is a vast difference in the language or given relief. Ultimately, reveal is that, my lord, relief is originated from the divisional
where
bench order.
where you
Divisional
heard where you heard by
divisional
the
order.
authorities in the policy decision.
So, my lord, it's a discrimination, my lord. Similarly,
When was the
same day appointment,
when
same
was
day
the policy
terminated,
decision taken?
then it will be a greater issue. Then I have to find another. Because otherwise rejected, my lord, that how can you discriminate it? Here also, my lord, I am pressing, my lord, how he can be discriminated. Because same day appointment, same day termination, order may be High Court, different advocates have filed a writ petition on different dates, it were disposed of by different honorable court judge. So, my lord, hereafter, my lord, the government has passed this order to what is there, and my lord, there should not be any difference. Other persons, my lord, so other
Pass
persons.
orders. We'll pass orders.
Huh?
Heard. We'll
Then,
pass
my lord,
orders.
if your lordship is not satisfied, then, my lord,
We don't know. We'll pass orders.
no,
Whether
my
we are
lord, it will be
satisfied or not.
difficult because, my lord, I have got very good
we
response
can
from other
only
courts, my lord.
we-
He has taken this matter, my lord.
we
I don't know why,
we
but,
can
my lord,
only
he has got,
we can only expect whether we can only
no, my
question.
lord, then I lost the case, my lord. I lost the case, my lord. In that case, if your lordship think differently, my lord.
I don't know, we
Because
pass
some
orders,
issue-
that's what he said.
No, my lord, no, my lord, that
You'll
my
have to-
lord said before.
If you are aggrieved, you have to go in appeal, if not, well and good.
So many.
Your case is
times,
on a
my
very
lord,
limited compass. You want a similar order. This similar order, on what basis that similar order is to be passed, no facts are pleaded. The orders are different. You have not put the
Orders
challenge.
are different, my lord. The government has passed the different orders. That is
Now,
discriminatory.
how will the court decide on that unless you plead the proper facts? Whether the government has correctly passed or incorrectly passed, you are making a submission that it has been incorrectly passed. High-handedness or discriminatory.
There is no pleading as to that, my lord. So, my lord, I may be allowed to file an additional affidavit, my lord, bringing all these facts, my lord.
After we have
because
spent
in
considerable
the
time. We have spent considerable time, so I think we will
next
close
week,
the
my
matter.
lord, it may fix. Otherwise, my lord, I am in difficulty because in other court, my lord,
All right, we'll give you 1 week's
Mr.
time, you file it.
Mr. Bora.
We'll give you 1
Bora
week's
was-
time. 1 week's time.
Yes,
All right. List the matter again on
it cannot be differentiated. my lord.
29th. 29th?
29th is, my lord,
On
can it be on court?
let it be on
Appeal
third,
rule, appeal rule,
Hmm?
29.
April 2.
third,
29,
3rd of May.
3rd of May.
All right, we'll have it on 3rd of May.
Yes.
We are putting both the matters to be listed on 3rd of May.
It should be segregated, my lord. It has nothing to do with
It is
him, my lord.
connected, we'll see. Let it be on 3rd of May.
It will be segregated, my lord. My matter may be
How does
segregated.
it make a difference to your case?
My lord, his case is different, my case is different.
We'll decide the matter together, no problem. We'll pass separate orders for your satisfaction. You want to file an affidavit, we are giving you a
Additional affidavit, my lord.
additional affidavit. Matter stands adjourned at the request of
The High Court order I will annex, my lord.
counsel for the petitioner in item 3 to file an additional affidavit. Is both the matters again on 3rd of May for motion hearing. These are for motion. Mr. S. Bora for PTC, Mr. P. N. Sharma for
Education.
elementary.
In this case, so we file an IA for modification of the interim order. Lordship, I talked to my friend, Lordship may dispose of the entire matter on some hearing date, because my application may be treated as my affidavit.
I have also filed a reply to their IA. okay? Basically, our cases, I'm just, even though my learned friend is not ready to hear the matter, I'm just pointing it out, only a very small issue. We have come before Lordship for non-payment of my salary for a particular period. Now they came up and said that you are absent for so and so, a few days, 6 days, 4 days, they have given that. And they have stopped the salary. Your Lordship has initially passed an interim order directing that the current salary may be paid. That has not been paid. We filed the contempt. Now they have come up by this I saying that you were absent for so and so date in this period. So whatever be. But just because of that, you cannot, if it is a punishment, then there has to be a inquiry and the process should follow before curtailing my salary, whatever it is. So that is the issue, Your Lordship. Since my learned friend is not ready, I have no objection, but this is the issue.
That the matter be listed again on
Any hearing date, it may not take much time.
16th May,
Okay.
to be listed for on 16 May, an attempt will be made to dispose of the
Much of
The interim to continue.
interim order passed earlier.
Much of
Your Lordship, Senior Counsel, Mr. G.
1 minute, 1 minute. A2. Yes,
Lordship, Senior Counsel Mr. James Sahewala is on legs in another court. Matter may kindly take up after some time.
Mr. Ahmed,
Okay. Last occasion he was not here.
no, we are informed he is here, but in some other court.
No.
All right, we'll keep it aside for some time. Some time. Take it up after a while. Please inform him.
Item 7.
Late regular. On an earlier occasion, your lordship has asked regarding Rule 12(3), my lords, of pay and allowances rules, my lord. And I have also got this, and it is in favor of me, my lord. The rules, what it says, my lord. You'll produce, your lordship will kindly see what it says. Did you hear? Did it? Yes. Now, if your lordship kindly see the rule, I was put under suspension, my lord. And I have not been allowed to work also. Once I have been filed my application for revoke the suspension. Now what it says, my lord, that kindly see when an employee who had been dismissed, removed,
Here, reading rule.
Rule
12,
12,
Lordship,
12(3),
Page 17, Lordship.
my lord, if you kindly see, Regulation 12(3) of the pay and allowance regarding suspension period provides the following. When an employee who had been dismissed, removed, compulsory retirement, or suspended, or reinstated, or would have been reinstated, but for this retirement on superannuation while under suspension, the authority competent to order the reinstatement shall consider and make specific order. Number 1, regarding the pay and allowances to be paid to the employee of the period of his absence from the duty for the period of suspension ending with the date of his retirement, as the case may be. Whether or not the said period shall be treated as a period of span on duty. Second, where the authority mentioned in clause A above is of the opinion that the employee has been fully exonerated, kindly take note of this, exonerated, or in the case of a suspension that was wholly unjustified, the employee shall be given full pay and allowances to which he would have been entitled. He had not been dismissed, removed, compulsory retirement, so and so, my lord. So 2 is, B is, my lord, absolutely on my case, my lord. C in other case, my lord. C will be different, man. They have taken into consideration C. In other cases, my lord, this is other cases. The employee shall be given a such proportional sign, so. Here is a case, my lord, where there is no DP, my lord. I have been fully exonerated from the criminal cases, my lord. And secondly, while revoking, while I have filed an application for revoking my suspension, that said that it will be outcome of the criminal cases which has been pending before the court of the CBI, my lord. That's what their stand is, my lord. So why I am not entitled for entire pay and allowances? Why this I have not been treated as on duty, my lord? They have restrained me, my lord.
What are the other cases?
Lordship, in other cases means, Lordship, when it is, when the suspension is justified as per the committee, the review committee. Lordship. Now, in this case, Lordship, if I may just read the order of acquittal, Lordship, that is at page 30 of their
No,
petition.
we are not concerned with the whether it is onerous or
Lordship.
not honorable or not onerous.
Lordship.
That we are not going into because your order doesn't say so. Where is the order of the appellate authority?
Order of the appellate authority is in my affidavit, Lordship, that is at page 58, Lordship. 58 is the operating part, Lordship. Annexure 3 of my affidavit, Lordship.
Yes.
Yes, your Lordship. So, Lordship, in this case, Lordship, the order has specifically stated that he was not considered on duty, Lordship. The
Now
suspension.
he was placed under suspension. Why?
Because of the criminal case which has been instituted against him, Lordship, by CBI.
From which he was acquitted.
He was later on acquitted, Lordship.
So where is the basis to say that the suspension was justified?
Because, Lordship, that is the whole concept, Lordship, because we were, the review committee was of the opinion, because since the allegations were serious of corruption, Lordship, and thereafter he might be acquitted, but your Lordship very well knows that the bar standard of proof In a criminal case, is very high, Lordship.
Provided you have instituted a departmental proceeding
Yes, my
against him.
Lordship, but the same thing had been already, case has been instituted, Lordship, and 33 of the rules allows us to put up employee on suspension, Lordship. So we were on that, Lordship.
Suspension, where is on what basis are you giving that finding?
Lordship,
Somebody files an FIR,
Lordship,
makes a series of allegations,
Lordship,
or let us say, pursuant to an investigation, there is a charge sheet filed,
Lordship,
where then charges are framed.
Lordship,
There are 2, 3, 4, 5, 6 charges framed.
Lordship.
Then the matter goes for hearing, and finally the judgment comes acquitting the accused.
Lordship.
Are you going to say that no, the charges have been very serious,
Lordship.
therefore, notwithstanding the acquittal, the charges will remain?
Lordship,
Does it have any value after the case, after the accused has been acquitted?
we reinstated him, Lordship.
You reinstated,
Yes, Your
but
Lordship.
where is the basis or the material to say that the suspension was justified?
Because, Lordship, at that point of time, because we had not initiated the criminal proceedings.
The acquittal
Lordship,
will relate back to the date of filing the FIR.
Lordship.
Everything, there's a completely clean slate.
But Lordship, if I may, Lordship, but if in the scenario, if it would have been us who had been lodged in the FIR, then it would have been a scenario, it would have been understandable that yes, he's acquitted, so he needs to be given full pay, Lordship.
How
But
does
this
it matter
FIR
who has lodged the FIR? It is with regard to the criminal proceeding.
Lordship,
That proceeding has ended so far as the petitioner is concerned, acquitted.
ended, Lordship, but the judgment order never says or states that the allegations against him were false. It was just, Lordship,
would
the
have-
standard of proof regarding a criminal case,
no,
Lordship.
no. Where is the judgment of the criminal?
The order is by in their writ petition, Lordship.
Where is that?
It's
Please
at
read the
page,
order.
yes, Your Lordship, at page 30, Lordship, of the writ petition. Page 30, Lordship, of the writ petition. If I may read, Lordship. Order date 7/4/21.
Hmm.
Today is fixed for judgment, peruse records and documents. In my view, the prosecution has failed to prove its case against the accused beyond all reasonable doubt.
What is the principle of evidence or proof in respect of criminal matters?
Yes, Your Lord, it has to be proved beyond reasonable doubt, even if, Lordship, what the criminal jurisprudence says, even if there is a single small iota of doubt.
Where is the order of the criminal court?
Well, it's a very big, that's why we have about 250 pages judgment, my lord.
No, we wanted to see what was the finding of the criminal court. In the court.
Finding is entirely they failed to prove this case because it's a trap case, my lord. The trap case was this because that case was being conducted by me, my lord. It was a trap case, my lord.
What remains?
Lordship, that's why the order has not been also brought in this court, the judgment, Lordship. Because if
It is
that
a
means-
fact, it is a fact that
Do you have a copy of the judgment? Is the copy of judgment available before the authorities?
No, Lordship.
No. Then on what basis have you said that he has not been exonerated?
No, because of the fact that the order which has been placed before
No,
this
this is
court.
the order. This is the order indicating that there is a judgment which will come subsequently separately annexed.
Yes, Your Lordship, but that has not been provided to us.
Where have you stated in your appeal that it has not been provided?
No, Lordship, because what the order states, because they are relying on this order, Lordship.
Mr. Counsel, when you make an argument, make a legal argument.
Lordship,
Don't make a political argument.
Lordship,
Don't make an argument because you have to make an argument because you have earned the fee. Make an argument on the basis of the facts and the law.
Lordship.
We would like to see a counsel making arguments with regard to the merits of the case.
Lordship.
You are arguing as if you are an officer of the ONGC.
No, Lord.
I would have accepted an argument like that from an officer of the ONGC. You are a lawyer. Then show us on what basis this order has been passed.
Lordship, on the basis of the rule of ONGC pay and allowances rules, Lordship, 3 clause C, Lordship. In other cases, Lordship, here it implies that.
That's all you have, nothing more.
3C, Lordship, is on the basis of which the order has been passed.
Yes, Mr. Bora,
my lord, the entire case was because of
you have not placed the judgment also.
well, judgment. If you lordship, I will place
It's
tomorrow.
not about me. He has raised an objection.
No,
that you have
we
not-
have no, we have played. But what he said, my lord, being an officer of the court, my lord, it's my duty to place before that. We have it's a voluminous judgment, my lord. We have given along with this copy to them, my lord. Is
He
it
says
200 pages? Judgment?
he
If
says
your
it is
lordship
not
wants,
there.
Milord, I can give you tomorrow also.
No, he says it is not there.
Well, not there, Milord. Where we file here, we have filed along with the judgment, Milord.
Hmm.
Certified copy, Milord. Initially, they do not accept the photocopy. We have furnished the certified copy, Milord. It's a 250 pages of judgment, Milord. It's a trap case, Milord. 40 witnesses has been examined, Milord. Only thing that there's no question of doubt that he was not acquitted. The question is this, whether it is what the plea they have taken, whether it is honorably or not. That is the plea, Milord, that I have already given a judgment regarding what the apex court has said regarding the acquittal, what is honorable and Milord not. Milord, Inspector General of Police versus S. Mathuraman, Milord. Milord, do you know?
Yes, please.
That I have given your lordship, Milord. Your lordship will kindly see paragraph 24, Milord. I again to refresh your lordship minds, Milord. That is the judgment and the paragraph 24, Milord. This is, Milord.
No, that of course.
So, my lord, what their stand is this. There is admitted fact, my lord. Is an acquittal is acquittal. Can he deny that he has not been acquitted? They cannot. As on now, my lord, the position is, so far the petitioner is concerned, he has been acquitted from all charge. And their stand was this, my lord. While I have filed an application for revoking my suspension orders, my lord, they say that it will be subject to the outcome of the criminal case, my lord. That's what they have said, my lord. And now, that why that period of suspension is not treated as on duty, my lord. I'm entitled for that. It is because of him they have not allowed me to join in my office, my lord.
Show us some authority on that.
My lord, yes. My lord, I'll show one cases, my lord, that is reported in 1991, my lord. My lord, what has happened here also, he was being exonerated. The matter has gone to the Central Administrative Tribunal and the full court has allowed accepting the pay and allowances of area pay allowances has not been paid, my lord. Now, in this, what has happened, my lord? The Supreme Court says, no, once he's been exonerated, he is entitled for everything, my lord. That lordship will kindly see. Yeah. Paragraph 7 onwards, my lord. 6 onwards, my lord. And you see, 6 onwards, my lord. I'll not skip all these things, my lord. What are the contention thereafter? 7, my lord. 7 is a long paragraph, my lord. Full bench, what?
This is with regard to steel covered.
My lord, but the proposition of law what has been stated, my lord, that is that page, this thing, from page, paragraph 7, my lord. And page 2, just place that paragraph only. That is on the next, that is, we are therefore, my lord, if a lordship kindly gets it, we are therefore broadly in agreement with the findings of the tribunal that when an employee is completely exonerated, meaning thereby that he is not found blameworthy in less and is not visited with any penalty even in censure, he has to given benefit of the salary of the higher post along with the other benefit from the date on which he would have been normally been promoted, but for the disciplinary criminal procedure. However, there may be cases where the proceedings where disciplinary or criminal are, for the example, delayed, or instance of the employee or clients of the disciplinary proceeding or acquittal in a criminal proceedings is worth with benefit of doubt or on account of non-availability of evidence due to the act of the attributor to the employees, etc. In such circumstances, the concerned authorities must be vested with the power to decide whether the employees are all reserved and salary intervening period, and if is that the extent on which the deserved it life being completed, it is not possible to anticipate and enumerate the exhaustively all the circumstances under which the consideration may be become necessary. To ignore, however, such circumstances when there exists and lay down and inflexibly rule in any cases when an employee is exonerated from disciplinary criminal proceedings, he should be entitled to all salary for the intervening period is to undermine discipline and administration and jeopardize the public interest. We are therefore unable to agree the tribunal that to deny the salary of an employee would all circumstances be illegal. While therefore we do not approve the said last sentence in the first sub-paragraph that after clause 3, paragraph so and so, remember, but no area space shall be payable. Or that is no area shall be payable. That also not agreed, my lord. So that was the, my lord, that paragraph, my lord. Particularly on that paragraph, I have just stated.
Is there anything under the rules? Any further provision under the rules?
Nothing, my lord. The rules 12.3, my lord, is clearly say 12.3, what the pay and allowances is said. That exactly covered my case, my lord. See, yes, I will agree if there is a disciplinary proceeding. I will agree with that. I will agree that yes, the disciplinary found so and so, so he is liable for any other cases. So the three clause will come. So far, this is the absolutely clear cases, my lord, on what basis in the appellate order, if your lordship kindly see what they have stated, they said that acquittal cannot be ignored, my lord. They himself said that the acquittal by the court of law cannot be ignored also.
Lordship, to that effect, I would like to place a judgment of the court. Lordship, in Gurpal Singh versus High Court of Judicature of Rajasthan, Lordship, 2012-13 SCC. Lordship, here in this case, if your Lordship comes to paragraph 34 of the judgment, Lordship. Paragraph 34, Lordship, if I may, Lordship. Similarly, the judgment cited by Mr. Sisodia reiterates the principle that no hard and fast rule.
Sorry, 1 minute. You are in paragraph
34, Lordship, page 111, Lordship.
Yes.
Similarly, the judgment cited by Mr. Sisodia reiterated the principle that no hard and fast rule can be laid down as to whether on reinstatement the employee is entitled to full back wages or no back wages at all. All the cases reiterate the principle that the facts and circumstances of each case have to be examined by the authority concerned. It has to take an informed decision on the basis of materials on record. These judgments also reiterate the acquittal of an employee would not automatically entitle him to reinstatement or to payment of full back wages. The power is normally vested with the disciplinary authority to hold a departmental inquiry, even upon conclusion of a criminal trial. Here in the case, the departmental inquiry was challenged, Lordship. That is why, but the ratio I want to place before his court. But the ratio I want to place before his court is that this clearly shows that acquittal itself does not amount to a person being exonerated honorably from a case, Lordship.
Provided
discipline authority.
hold up
Lordship. In that scenario, Lordship,
You have to read as a whole, my lord.
yes, as a whole, if it is read, Lordship.
That is what we have been repeatedly asking you for 20 minutes.
Lordship.
What is the basis on which you are withholding the
Lordship.
pay? What is the basis?
Rule 30, Rule 12, Lordship.
Rule 12
that is
doesn't
the
say so.
12C, Lordship.
No, it doesn't say so. What are the other cases? What other cases?
In other cases where it is not found to be,
Where? Kindly
Lordship, if I may again
read again.
bring the rule, Lordship.
Read again.
12.3 says, Lordship, 3A, when an employee who has been dismissed, removed, compulsorily retired, or suspended is reinstated or would have been reinstated, but for his retirement or on superannuation while under suspension, the authority competent to order the reinstatement shall consider and make a specific order, Lordship. Thereafter, Lordship, clause B, Lordship, says that where the authority mentioned in clause A above is of the opinion that the employee has been fully exonerated, or in the case of suspension, Lordship, that it is wholly justified.
Unjustified.
Oh, sorry, Lordship, that is wholly unjustified. The employee shall be given the full pay and allowances to which he would have been entitled to had he not been dismissed, removed, compulsory retired, or suspended, as the case may be. In other cases, Lordship. So this other cases, Lordship, implies where the authority finds out or authority comes to finding that the suspension was not wholly unjustified.
Where is the finding?
It has been, Lordship, in the order itself, Lordship.
Where is the finding? And, or rather, more precisely, on what basis the finding has been arrived at?
Lordship, Lordship, at page 58, Lordship, paragraph 8, fourth paragraph, Lordship. From the facts and circumstances of the case, it is evident that though his suspension of Sri Lal Locham was not wholly unjustified for the reasons mentioned above, yet his acquittal by the court cannot be ignored by while deciding this appeal. Now, Your Lordship, the reasoning is this, that it is observed that Sri Locham so and so was caught red-handed by the allegations have been brought in, Lordship, and on that basis, Lordship, considering these are allegations of corruption, the department took the decision, Lordship.
Allegations are allegations.
Lordship.
It'll have to be proved.
Lordship.
Unless it is proved, there is no meaning.
Lordship.
So what is the point in going back to the allegations when the criminal court has acquitted him?
The basis of rule 12, Lordship, that is where the department comes to a finding of the case, Lordship.
Heard, learned counsel, Mr. P. Ora for the petitioner assisted by Ms. Swendru.
K. Sharma.
A. Sharma. A. Sharma or K. Sharma?
K. Sharma.
K. Sharma. Mr.
M.K. Das, Lordship.
M.K. Das, standing counsel for ONGC. The writ petition is filed by the petitioner, aggrieved by the order dated 21/2/2022, passed by the Chief General Manager within bracket HR of the ONGC, whereby the petitioner was directed to be given such proportion of pay and allowances as the competent authority may specify, and consequently he was allowed 95% of his pay and allowances for the relevant period under which he was placed under suspension. So the petitioner, that apart, the period of suspension was not accepted to be treated to be on duty. Stop. Para, it is submitted by the learned counsel that there was the petitioner was an employee of the ONGC, and at the relevant point in time, he was serving as the deputy DGM, deputy general manager within bracket civil, and was posted in Sibsagar. So, during the period of his service, certain allegations were made against the petitioner in respect of what allegations were made.
That he has been caught red-handed, my lord.
That he was caught red-handed accepting a
As a bribe.
while in discharge of his official duties. So, accordingly, an FIR was lodged and it culminated into a criminal case being R/C-017/2016/0008/CPI/ACB/Guwahati dated 7/6/2016. Stop. Subsequently, charge sheet dated 27/9/2016 was filed for offences punishable under Section 7, Section 13(1), within bracket D, small d, read with Section 13, within bracket 2, Prevention of Corruption, 1988, in case number RC 8, within bracket capital A/2016-GWH. So the trial proceeded, and ultimately by judgment and order dated 7/4/21.
My lord.
Judgment dated
7/4/21.
same day.
Same day.
7/4/21. Petitioner was acquitted of all the charges, as the trial court held that he trial court held that the prosecution failed to prove its case against the accused beyond all reasonable doubts. So The judgment was rendered by the Special Judge CBI Assam, Additional Court Number 2, Chanmari Gorgi. So
No appeal also been preferred by the CPI.
it is mentioned that during the currency of the proceedings initiated by the CBI, the petitioner was placed under suspension by. Where is his suspension order?
My lord, will find at page
23.3.
9th, 21 of my writ petition, that is order dated 9/6/2016 below. Page 21.
28/3/2018, whereby he was placed under suspension. No. Where was he? When was he placed under suspension?
Yes, my lord, page 21, my lord. That is
21.
09/6/2016, my lord, of my writ petition.
09/06/2016,
16 below.
whereby he was placed under suspension. Placed under deemed suspension. The petitioner continued to remain under suspension, and subsequently he superannuated while under suspension. So, was there any order passed permitting you to superannuate?
My lord, that is, there is no, my lord. Your lordship will kindly see what that is at page 29, my lord, annexure 7, my lord. That order of 28/3/2018, my lord, the last paragraph. Now, therefore, keeping in view of the above mentioned facts, circumstances of the case, the recommendation of review committee director is decided not to revoke the suspension of so-and-so and allow him to superannuate, my lord, on 31/3/2003 provisionally, while under suspension, subject to the issue of the final order based on the outcome of the judicial proceeding, my lord. Page 29, my lord, annexure 7. That is the last line.
Stop. Before superannuation, you write that the case of the petitioner was reviewed by the review committee, and the review committee recommended that the suspension of the petitioner be continued, keeping in view the allegations made. Stop. Subsequently, petitioner was permitted to superannuate by order dated 28/3/2018. He was allowed to superannuate provisionally while under suspension, subject to final orders based on the outcome of the judicial proceeding. So, as discussed, the trial court by judgment and order dated so and so exonerated the writ petitioner of all charges on the ground that the prosecution failed to prove all the charges beyond reasonable doubt. So, against pursuant to the judgment and order, the petitioner preferred an appeal. Right? Pursuant to the requirement, petitioner preferred a representation dated 12/4/2021 before the competent authority of the ONGC for release of his pending dues. So, the disciplinary authority rejected his representation for release of the full salary and allowances for the subsistence during the suspension period. Stop being agreed. He preferred an appeal for the appellate authority dated 21/1/2022. Stop. The appellate authority although accepted the acquittal of the petitioner granted by the trial court. However, invoking Regulation 12.3 of the ONGC, Regulation 12.3b of the ONGC decided to allow the petitioner 95% of his pay and allowances due for the relevant period. So, being agreed, the present petition has been filed. The respondents have contested the case by filing their affidavit in opposition. So, you have filed your affidavit in
Yes, sir.
opposition.
Lordship.
It is submitted by Mr. Das, counsel appearing for the ONGC, that authorities have rightly passed the order granting 95% of the pay and allowances as it was held under the relevant provisions of the regulation of the ONGC, that the grounds on which the petitioner was suspended and the allegations made against the petitioner were of grave nature. So, although the trial court has acquitted the petitioner, but the acquittal is not at all an honorable acquittal, as the case was, as the acquittal was on the ground of the failure of the prosecution to prove beyond all reasonable doubts. So, learned counsel for the respondents have referred to the ONGC pay and allowances regulations 1972 and executive instructions. So, is referred to clause 12 of the same regulation to submit that under clause 12.3b, read with clause C, there is a power on the authority to release the pay and allowances as deemed justified. So, he has further referred judgment of the apex court rendered in Gopal Singh versus High Court of Judicature, Rajasthan, reported in 2012, 13 and 16, 94. It is submitted that in respect of reinstatement of the employee with regard to full back wages or full wages, there is no hard and fast rule. Everything has to be decided on the materials available, and the authorities are within their rights to decide the as to the extent of back wages or full back wages required to be granted to an employee. So, relying on the judgment, learned counsel for the respondents that in the present case, where the rules provide that the authorities are to decide on the extent of back wages required to be released, and the authorities have decided that 95% of the back wages or allowances payable to the petitioner are to be released per month. There can be no infirmity, and there can be no infirmity found in the stop. The writ petition, therefore, being devoid of merit, should be dismissed. Insofar as the petition is not one, the writ petitioner has been relied support of his contention on the judgment of the apex court rendered in S. Samuthiram, reported in 2013, 160, 598. relying on the judgment, the learned counsel submits that once an acquittal is granted by the trial court, after full consideration of the prosecution evidence, and that the prosecution had failed to prove the charges leveled, it can be possibly said that the accused was honorably acquitted. Stop. It is submitted that the apex court held that the terms, that the expressions honorable acquittal within quotes, comma, acquitted of blame, comma, and fully exonerated are unknown in the Code of Criminal Procedure or the Penal Code, and these are coined by judicial pronouncement. He is further referred to and relied upon the judgment of K. V. Janaki Raman, reported in 1991 SC 2010, to submit that where an employee has been completely exonerated and is not visited with any penalty, he has to be given the benefit of his salary and allowances, which would have been entitled to him but for the criminal proceedings. Learned counsel to the parties have been heard, reading the record have been kept the truth. It is seen that the petitioner was placed under suspension on certain allegations made against him, which ultimately culminated in a criminal proceeding, being criminal case number so and so so and so. So the charge sheet was filed on so and so. The matter proceeded to trial, and by judgment and order dated where is the judgment and order dated?
7/4/21 Lordship, Annexure 30 of the writ.
7/4/2021. The trial court acquitted the acquitted the accused, namely the petitioner, holding that the prosecution had failed to prove its case against the accused beyond all reasonable doubt. So, while the petitioner, pursuant to the institution of the criminal proceeding, was placed under suspension, his suspension was never revoked, and during the suspension, he was permitted to superannuate provisionally. So, pursuant to his superannuation, petitioner preferred a representation before the authority for release of all his allowances and pay, particularly during the period of his suspension, with a further request to regularize his period of suspension to be on duty. So, this request made by the petitioner by way of his representation was rejected by the disciplinary authority, and against which he had preferred an appeal before the competent authority. The appellate authority also partially allowed the appeal by permitting release of 95% of his allowances. Stop. The petitioner is aggrieved that, notwithstanding he is acquitted by the criminal court, the authorities could not have curtailed release of his pay and allowances to the extent of 5%. The ONGC has its regulations named Pay and Allowances Regulations 1972 and Executive Instruction. Under clause 12 of the said regulation, relates to suspension and the allowances required to be paid to an employee under suspension. So, for the purposes of this case, clause 3, subclause 3 of clause 12 is relevant. So, subclause clause 3. The relevant extract of subclause 3 is reproduced below. Clause 3, A, B, C. Correct. Having heard the rival submissions and upon careful perusal of the report, as well as the rules placed before the court, what is not in dispute is that pursuant to the petitioner being placed under suspension post the institution of criminal cases or proceedings against the writ petition, no departmental proceedings have been initiated. So the petitioner continued to remain under suspension and was finally permitted to superannuate. The criminal proceedings which was instituted ultimately culminated into an acquittal, acquitting the writ petitioner from all the charges made on the ground that the prosecution failed to prove the case beyond all reasonable doubt. So, that being the position, no further that apart, no further appeal against the criminal matter.
No, CBI by CBI.
It is submitted by at the bar that there was no further appeal filed by the CBI. The acquittal given to the writ petition.
In fact, their my lord, orders, my lord, it also be reflect that CBI has not filed any. That is that para 58, my lord, paragraph, my lord, 8 of this. It has been given understand by the concerned department that CBI has not filed any appeal in the concerned court against the judgment of the special CBI court.
The said fact is also reflected in the appellate order dated so and so, where the appellate authority has recorded that the CBI has not filed an appeal against the judgment of the special CBI court. So, a careful perusal of the Pay and Allowances Regulation 1972 does not reveal anywhere that the authorities have any power to inflict any punishment on any employee or curtail any salary or allowances without following the due process of law. On facts, as discussed above, there is no dispute that no disciplinary proceedings have been initiated against the writ petitioner pursuant to the petitioner being placed under deemed suspension. He continued to be under suspension and was permitted to superannuate. So, that being the position, pursuant to the acquittal of the petitioner by the criminal court, all the charges have been held. The petitioner was given complete acquittal by the trial court. Stop. Whether such an acquittal is an honorable acquittal or complete acquittal is an issue which is also not discussed by the disciplinary authority or by the appellate authority. So, the only reference that is found in the impugned orders is with regard to Rule 12 B, subclause 3. So, a careful perusal of this Rule 12B subclause 3 reveals that where the suspension of the employee is found to be not wholly justified, was not wholly unjustified, he shall be given full pay and allowances to which he would have been entitled had he not been dismissed, removed, compulsorily retired, suspended, as the case may be. Rule 12BC provides that in any other cases, the employee shall be given such proportion of such pay and allowances as the competent authority may specify in the state. Stop. The rule does not elaborate any further as to what would be the cases to be considered within quotes under such cases. To be considered under within quotes such cases. So, the impugned order of the competent authority also does not reflect the basis of their satisfaction that the petitioner is not to be entitled to full pay and wages, but to be granted only 95% of his pay and wages. So, it is no longer res integra that suspension is not a form of punishment, and therefore the same cannot be treated to be used against any employee as a form of punishment. So, there is no dispute that the petitioner had rendered his services and therefore is entitled to the pay and allowances as permissible under the rules. So, the only source of power available under the rule is for the authority to arrive at a satisfaction that the employee is not entitled to full pay and allowances, but for the sake, but for reasons to be expressed by the competent authority. So, a careful perusal of the disciplinary authority, the orders passed by the competent authority as well as by the appellate authority reflects that notwithstanding that the authorities have accepted the orders of the trial court and notwithstanding the fact that no disciplinary proceedings have been initiated or that the petitioner have been awarded any penalty under any departmental proceeding, the authorities went on to arrive at a finding that the allegations against the petitioner were of grave nature, notwithstanding that the petitioner had been completely acquitted by the trial court. So, once an employee is acquitted by the trial court, unless there are some proceedings initiated against the petitioner in respect of the said allegation, there can be no finding arrived at by the authorities to hold that to arrive at a finding that the allegations which were made against the petitioner and which culminated into a criminal proceeding in which the petitioner ultimately was fully acquitted, was completely acquitted, the same cannot be the basis for arriving at an order for withholding of any part of the pay or allowances without there being a reference to the source of power available to the authority concerned. So, While there is no quarrel with the proposition of law submitted by the learned counsel to the respondent, that there is no hard and fast rule for grant of pay and allowances or back wages in respect of an employee found to be exonerated from criminal proceeding or from department proceeding. The fact remains that there must be a basis and a reasonable basis on which the authorities must come to a conclusion that the petitioner is not entitled to the pay and allowances which he would otherwise have been entitled to. So, in the facts of the present case, on a perusal of the impugned order, no such basis or reasons are discernible from the order. So, the authorities have merely referred to the gravity of the charges leveled against the petitioner at the time when the petitioner was placed under deemed suspension. So, these charges, subsequent to a complete acquittal by a trial court, carry no further meaning and cannot be used as a basis to draw adverse inference on the services or on the conduct of the petitioner. Under such circumstances, this court is of the considered view that the impugned order dated so and so, passed by the disciplinary authority as well as by the appellate authority, curtailing the curtailing 5% of pay and allowance of the writ petitioner
And also,
cannot be allowed to be sustained. And
also, my lord, if that period can be treated as a on duty.
in the absence of any departmental proceedings initiated by the respondent authority, such curtailing of pay and allowances is found to be bad in law, and the same is therefore set aside. So, the authorities are further directed to regularize the period of suspension of the writ petitioner to be considered to be a period on duty
From
and
7/6/2016 to 31/3/2018.
from 7/6/2016 to
31/3/2018.
31/3/2018, and therefore the said period of suspension should be treated to be on duty, and the petitioner be entitled to full pay and allowances as he would have ordinarily been entitled to had he not been placed under deemed suspension. Stop writ petition in terms of the above, therefore allowed. Impugned order dated so and so, along with the order passed by the disciplinary authority, to the extent indicated, is therefore set aside and quashed. No order is proposed.
But ONGC may be allowed to pay pay and allowances within a month.
The ONGC is directed to release the pay and allowances to the petitioner in terms of the directions above within a period of 30 days from the date of receipt of a certificate of yes. Yes, please. Yes, please.
This is the case to pray for grant of gratuity, which was denied to the petitioner in spite of having served the supply tea research association for over 13 years continuous. There's no break in service. And the law is clear under the Payment of Gratuity Act.
Yes.
Any employee serving for 5 years or more is entitled to claim.
Payment.
That's for Section 4 of the Act.
Yes.
Payment of gratuity. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years. And the reasons have been given. The petitioner was appointed on a contractual basis.
Hmm.
Admitted position. But I was allowed to continue for 13 years, 3 months, 14 years, 3 months, without a single day's break. Worship, on 17 August 2000, Annexure 10 at page 20 of the we claim. I've claimed for retirement dues on completion of my contractual service has been denied to me. And that is the basis for which we are coming to the lawsuit. The law is settled that
What is the stand of the respondents?
respondents
Why
say
they denied?
they are only going on the plea of alternative remedy, provision of appeal. We have given the details of the period I have served, 14 years, 3 months at page 21, which has been admitted by the respondent number 5 at page 22. In case of Dr. B.K. Doctor, retired medical officer, it has been found that though he was under contractual engagement, he had completed 14.5 years of qualifying service without any break in service since his initial engagement, with effect from 1/7/2000 to 39/2014. His last consolidated pay was 25,000 rupees. How will you say it? He is 84 years today. So this long tenure of service, it was not at my choice. They asked me to continue. They're denying me the minimum legal use as contemplated under the payment of gratuity. Ruling. No, not here. I will to Rahul. Rahul, please. You- They're not disputing that it is not a state. They took like this is the association.
They are not disputing.
No, not
Why are they raising preliminary objections?
they stated so, but the rulings of this honorable court also saying it is a state. This has been held to be maintained.
He was not appointed in a permanent post,
No, it was a contractual.
contractual. So our
Initially for 5 years and then it continued.
are contractual employees covered under this act?
Yes. Whoever the employee may be, there's no exclusion clause. Any employee serving under the organization Madras High Court की request है राव की वजह से एक okay. Your Worship, as far as the supply tea research association is concerned, it has been held to be a state by this honorable court in a judgment passed in WPC 5134 of 2005. This is by Justice Sridhar Rao. At page 2. The petitioner here was also working the supply tea research association, and in this honorable court held that they said association is a state within the meaning of Article 2. Hmm? We will- Hmm? This is of course a case of Madras, Madras High Court.
This is, how is this case relevant?
As far as meaning of state is concerned.
Oh, yes, oh, yes. The T-board is a state. There is no quarrel on that.
That was the,
Because it has a government,
yes, one thing is
control,
that.
central government control is there.
And then and Lordship will please look into 2012 SCC online Madras 417. In this case, the Honorable Court held
That Khalasi is also entitled.
is entitled.
There are orders of this court, only, I think. Okay.
Justice Patricia Singh had also held that gratuity was payable. This was in WPC 6063 of 2013.
WPC
6063 of 2013.
Do you have the party name?
Your Worship?
Or you have a copy?
Yes, you've given. Nagendranath Bora versus Union. It was in respect of regular employees, but gratuity is being paid. Yes, potential thing judgment which has placed before your Lordship. His Lordship had held that other than gratuity, I was also entitled to receive leave encashment benefit, which has been denied to me. Last paragraph. Yes.
That's all. That's your case.
That's my case. I'll submit in case he has.
So they have taken a point, Malad, that stage alternative remedy under,
What is that alternative remedy?
Malad, if it is there, Malad, section 7, that they can file an appeal.
Section 7.
7 for A and B. Section 7, subsection 4, then B also.
This is with regard to amount of gratuity.
Uh,
Section 4 is amount of gratuity.
Next, my question is this, Malad, that as I have said, that this was a contextual employee. If your losses see, Malad, the page 58, the original letter.
So he does not dispute that it is a contractual.
Contextual, if your losses see, Malad, the section 3, my learner said at 4 as in place. 4, whether it is attracted. Section 4 does not attract, Malad, here.
Section 4 does not exclude.
Yes, Malad, here also come. Gratuity shall be payable to an employee on termination of his employment.
Right.
After he has entered contract service for not less than 5 years on his superannuation.
Right.
on his retirement or resignation, on the death or disablement of the accident disease. So these are the conditions. Irregular employee, my lord, not contractual. And employee definition is also there, my lord, employee on wages. That is 2C. 2C, and wages is very important, my lord, here.
Employed for wages.
Wages, and wages is 2S. Wages means all emoluments which are earned by an employee while on duty.
No, sir.
Now here, my lord, if you also see page 58, what he has been granted? Contractual, my lord, he has given only provident fund. Except that, nothing, my lord.
You show us from some authority that contractual employees are not covered under employee.
Well,
I
am not
He has
doing
placed a judgment.
the judgment, my lord. I am not placing here now to, I am not brought it. But section 4 say, but the person, he employee termination on superannuation, retirement or resignation or death or disablement. Well, there is no question of superannuation, my lord, because this is a contract for 5 years. If you also see page 58, my lord, affidavit no question.
Yes.
We have said, my lord, clearly.
He has not disputed that it is
No,
a
no,
contract.
yet we have mentioned, my lord, we have also see what he will get.
58.
58.
Yes.
This is the first letter, my lord. Subsequently, extension. With reference to the interview with the chairman, management is pleased to offer you the post of medical officer in association control pay of rupees 20 per month. You will contribute 12% of your salary to the provident fund account, and the association would make equivalent contribution. So, provident fund you will get. Apart from the consular pay, no other charges or allowances will be admitted. He accepted this, my lord. Your lordship should see next, my lord, page 60.
No,
Yes.
no. The crux of the matter is whether he's an employee is to be understood under the payment of gratuity.
My lord, I am coming to that. That is right. He has accepted that, my lord, page 60.
No, but if he's entitled to be given a gratuity,
Yes.
his mere acceptance to a letter cannot take away his right under the
No.
statute.
I agree, my lord. Only thing, contractual employee labor superannuation retirement does not arise, my lord.
That's all right, but
Because he is
some more direct authority on that, a little more precise authority on that, that a contractual employee is excluded.
my lord, in that case, my lord, from time we can
Okay.
make it up to that.
Because I think temporary employee perhaps is not entitled. Temporary. But whether
Temporary depend, my lord. Temporary employee depend. But contractual is, does not come within the temporary also, my lord. Contract is especially for the period given, my lord. Not beyond that.
this was contract for how many years?
First 5 years, my lord. Then it was extended.
So it was extended.
Extended, but specific term, my lord.
For how many years did you serve?
14 years, 3
14 years on contract.
Yes. Because in superannuation, my lord, date of retirement be there. There is no question of age, my lord. Because
That is an indirect interpretation.
Lord,
Give us a direct
my lord, your lordship,
authority on this.
and
Is there any authority to say that,
my
Mr.
lord,
Ahmed, is there any authority to say that contractual employees are included?
he has been appointed with PS, my lord, after retirement. His present age is 84.
No, that's right.
My
But
lord, after retirement, person is appointed on contractual basis. So there is no question of superannuation or retirement, my lord.
we are asking the learned councils to give us any authority to say that contractual employees are excluded.
My lord, that will be fixed next week, my lord. I shall try. That will be
Hard
part, my lord.
Hard learned councils for the parties at some length. Matter be listed for further hearing on. Give us a date.
Next week, any day, my lord. Hard. Hard. Hard.
We have 14.
We'll have it on 9th. 9th.
Yes.
14th is not possible. We can have it on 16th.
16.
16th. 16th.
No, I am paying for S1 number 2.
Mr. S. Bothakur for 2N.
And for 1 minute per accessory, I am paying for S1 number 1 minute.
For you are appearing on whose behalf?
I am paying on behalf of my assessor for S1 number 1.
Okay.
And for 2 I am paying.
How can you appear for both? Mr. S.S. Roy appears for union, Mr. S. Pothakur for respondent 2, Mr. Sahiwala assisted by M.S.
Keshav.
Keshav, and Mr.
4 and 5.
M.Z. Ahmed appears assisted by Mr. Dotto. And also heard M.S. P. Dotto. Matters be listed on 16th
As a part of
for further hearing.
part.
It's a part of.
Yes, yes.
This item number 8, 10, 11, and 6 are a similar matter. And similar and the stand taken by the government also.
In item number 16, we have not filed.
Item number 16, they have not filed affidavit.
Otherwise, in all the 3 matters, we have
Item
filed
number
our.
16.
Yes.
The petitioner before lordship already assistant teacher of a LP school. They are appointed in the year 1989. Thereafter, their appointment letter is annexed in the annexer ACD. Annexer 1, A, B, C, D. Their appointment letter. They are joining in their respective school and performing their duties. And after their appointment in 1992, their service were terminated.
Yes.
Their service were terminated, and they, without providing the due process of law, they opposed this honorable court. The honorable court, that is the CB rule number 61793. They all petition are in the same group, and it also find in Annex 2, page 35. That
Your grievance in this writ petition is for what? Area salary?
not. That is not. That is for the termination, challenging the
No,
termination.
in this writ petition.
This petition for the pensionary benefit.
And area salary?
No, yes. That some period of salary has been withheld.
Why it has not been accepted, your pension?
That page 37 is the order. Judgment, page 37 of order. And by this judgment, the honorable court set aside the termination order. Page 37.
Yes.
This order will be page 38 of Party Court notified. In view of the matter, Annexa T series order cannot stand, and accordingly, this order terminating service, the petitioner shall stand quash. The petitioner shall reinstated in their service. It is made clear that if there is any irregularity in making appointment, the authority may take action, giving notice to the petitioner and possession due notice to be given. And anyway, he will be shall reinstated immediately within a period of 1 month on the date of receipt of the order, and the salary to the petitioner shall be paid and after their reinstatement in accordance with law. That is the first order passed. Thereafter, they are reinstated they- and they also, their petition number 1 submit also confirm lordship to find in page 41. The petition number 1 submitted has also been confirmed. Therefore, lordship, they are sent. They all petitioners are sent to the for basic training, which is requirement for primary teacher, and they all completed their course and successfully, and that will that certificate will be lodged fine page 42 and extra 5 pages 42, 43, and 45. When they are deciding their duties, again on 2007, their salary has been stopped.
No, let us, you are starting from the beginning. We don't need from the beginning.
Yes.
Start from where you retire.
Yeah.
And you tell us to the extent
No, because
required.
I am apprentice paper.
No, that is irrelevant here because that litigations are gone. If you want to rely on an order, you place it. But here you are concerned with release of area salary and pension.
And
why the department has rejected it?
no, I'm sitting because of the fact that
Huh.
they filed an affidavit.
Yes.
They filed an affidavit.
We are going through it. Yes.
They raising in the question, my appointment was, I was terminated teacher.
Hmm.
And their affidavit, the lordship will say that I am terminated teacher. And moreover, they said there are no disciplinary proceeding or anything has been noticed as per act.
Do you have your order of superannuation, or when did you superannuate?
Which one?
When did you retire?
The petition number 1 is retired on 1/4/19, and petition number 2 is 2015, and third is 1/4/2019.
Is there any official document to say that you are retired on so date?
Yes, that's it.
Where?
Their affidavit was fine.
Attain the age of
Is there any official letter to that? Referring to their dates of superannuation?
Page 107.
107.
we have said they have attained the age of superannuation.
107. Page. It means that a petition number, you read petition, the one who person working at residential LP school, attended superannuation on.
You fall under which list?
Even if you say that they are list, that we are come under the list 1.
So you were working as assistant teacher and you retired on 30/04/2019.
Yes. Petition to Bogan Doctor is working, that is the.
Now why their pension is not paid?
Lordship, we have filed our affidavit. In our affidavit, we have verified that their initial appointment itself was illegal, Lordship. Lordship may kindly take up our affidavit, page number 106, paragraph 12. That the answering department humbly begs to state that although the petitioners, Lordship, because their initial appointment was illegal, therefore they were directed to appear before the screening committee constituted. They appeared before the screening committee. Now, Lordship.
Screening committee passed what order?
Lordship, paragraph 12. The humbly begs to state that although the petitioner participated in the said screening process by submitting a document and upon verification, the petitioner find place in category 3. Category 3 is those working, not recommended and working. But till date, and as per the aforesaid cabinet decision, the petitioner who fulfilled the aforesaid conditions were offered fresh appointment with prospective effect from the date of the cabinet decision according to their qualification. The name of the petitioners figured in the screening committee list 2. under Dhemaji district, list 2, received salary up to 2007, but no basic training. And the petitioners being untrained were accommodated under tutor under illegal and irregular category. However, it may be stated herein that the petitioners in the present writ petition, petitioner number 1, who was working in so and so, but attained the age of superannuation in 2014. Petition number 2 attained the age of superannuation in 15. Petition number 3 attained the age of superannuation in 31/1/2015. And petition number 4 attained the age of superannuation in 2019, 17. Therefore, in the peculiar circumstances, they could not accept the appointment, their appointment letters as accommodated tutors. Their name appeared in the list 2 for accommodation as a
So
tutor.
they have already retired.
They already retired.
Lordship will kindly check their affidavit, page 105.
They already retired. Only in that peculiar situation, Lordship, they could not be accommodated. Their name appeared in the list 2.
Number 1, Lordship will
There was
kindly.
another matter yesterday, day before, we had dealt with someone who is already retired.
Already retired, Lord.
That is why I am starting out with this, I am showing the judgment also because the fact that this court, while terminating, take aside the termination, because the irregular illegal discharge. That was terminated.
We are in admission. So if it is in admission, you tell us whether if the matter requires in-depth hearing, we are fixing it for hearing. If you think that it can be decided in a short point, we'll decide it. But if you have to tell me since the date of your appointment and what orders were passed, then you have to look into all that.
Only one thing, Lordship,
We were only hoping
on basis of this,
your grievance in the writ petition was with non-release of pension and arrear salary.
There is no prayer for arrear salary.
No,
Lord.
there is. You see the prayer? See the prayer properly? Page number 24.
24, Lordship.
Directing respondents to release regular pension and other so and so.
Directing respondents to release the regular
Sorry.
pension and other retirement benefits.
Sorry. In the synopsis it is there.
In the prayer, there is no prayer for salary.
Synopsis arrear salary from July 2014
Yes.
till retirement is not released.
No salary is paid. From 2014, they are not getting salary.
So you tell us if
and
we have to hear in detail, we'll have to fix it for hearing. We are taking up admission now. Whether it is to be admitted for hearing or not, that's all.
I know only one question, Lordship, is that may take it in hearing. I don't know.
Very well. Then we'll issue.
But one issue is, Lordship, a person, employee, is working. He was sent to the training. The court has come in 3 occasions. 3 occasions, they give relief to the petitioner. 2007, also court interferes the order. The court clearly said that if you have to pay the salary, they have to pay the salary after. But you cannot do that without any due process of law. He cannot be removed without due process of law. Thereafter, they are continuing. After retirement, even they say there are other person who similar to the petitioner but already been regularized and accommodated. They could not be accommodated, they are retired. They could not be accommodated, in the meantime they are retired. Their screening committee, their affidavit says that page 105.
They fall under list 2.
Yeah.
They fall under list 2.
List 2, Lordship.
So what does list 2 convert him?
List 2 is for accommodation as a tutor.
As a tutor.
Tutor. List 1 is for teacher.
So as a tutor, would they have been entitled to pension?
They would have no, Lordship. For tutor, there is no provision for because they are on the their salary is fixed pay, and they are not entitled. And but there is a provision, Lordship. Even if one is accommodated as a tutor, if in the due course of time they complete their basic training, they will be subsequently accommodated as a teacher in a subsequent period.
So as a tutor, no pension.
As a tutor, no pension. Teachers, they get a regular scale and they are entitled for pension.
Yes, they correct. List 1, Lordship, page 105. That is why I am with the list 1. What is the list 1? The teachers who have received salaries list 105.
Up to 2006.
2007.
Seven.
The petitioner is up to 2014. On what? And having JBT, B.Ed are included in list number 1. Was it fine? And the petitioner before your lordship as received their admission that 2014, and they have completed the junior basic training. Therefore, they have come under list 1. If he is come under list 1, then lordship come to page 106.
No lordship.
Here page 106.
Yes.
Approval sought for accommodation of those teachers who have received salary up to 27 and have successfully completed junior basic training. Course creating personal superintendent post with prospective date of approval.
When was the cabinet decision taken?
Yes.
2020 lordship.
Cabinet just 7th.
20.
Yes.
You retired prior to that.
Prior to that. Because of the fact we are our post, the petitioner, service are already confirmed.
All right, then
But-
we'll have to hear it.
but the
Learned
screening
counsel
process
for the
started in
parties,
2012.
it is submitted that the pleadings are completed for issue rule, matter be listed for hearing the month of June. We'll hear you
Lord.
on this, on every aspect. Mr. Mr. P.P. Borua for petitioner, Mr. P.N. Sharma for elementary,
Lord.
Mr. D. Bhattacharya for
Ye.
accountant general, Mr. A. Choliha for finance. We'll have to hear this matter.
Yes, definitely there is some disputed law to do here. Required to hear the matter.
So your claim is that if you had been included in list 1, if you had been included in list 1,
That is my submission. My submission is that I am regular as a regular teacher working as a regular person,
no.
and they are oh, yes.
Your claim is that you are a regular teacher, you retired, your pension has to be given. That's your case, as
Yes,
simple
yes.
as that. Their critical case is that you are all irregular teachers, you are screened by the committee placed you under list 2, therefore you are not entitled to pension. So your alternative argument would be that even if if there is a screening committee, I ought to have been placed in list 1.
One.
All right.
Very
But that will require examination of the facts, which is why we'll have fixed it for hearing.
And item number 16 lordship, we have not yet filed the affidavit, we filed the affidavit.
Let us say similar,
Whatever pleadings are there, you want to file.
May I please your lordship, item number 55 lordship, that may be taken up on next week lordship.
This is not a mention time.
Yes lordship.
So if you are not available, you are not available. I will not accept mention like this.
Lordship.
10:30 you make a mention.
Lordship, I was prepared to do, but not well to the at this moment. That's why I went. Okay, lordship, I will.
You inform the court master. Court master will take care of that. All right. Yes. This. Yes.
May I please the lordship? My lord, here is the case, my lord. It's squarely covered by a judgment which I have relied on the last date, my lord. And the affidavit, my lord, that does not reveal that the review was held within 90 days, my lord. Rather, my lord, it can be seen, my lord. The review was done in the month of February, more than 5-6 months. So my this prayer at this stage, my lord, let the suspension order be set aside, my lord. And I may be pleased somewhere else if it is they want to do. No purpose will
What
come.
about the disciplinary proceeding?
Proceeding, my lord, only show cause was issued. After that, nothing.
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 Yes.
Well, I today am a bit handicapped, my lord. I'll pray for this listing of matter on Tuesday.
That's okay. Tuesday, Thursday we'll do it. But the question is,
I can bring the status, update the status, what is regarding and honestly, my lord, I feel, but a person, my lord, suspended, doing nothing, getting 75% salary is also wastage of treasury money, my lord. Outright, suspension may be revoked and he may be posted to an insensitive post. But regards that, well, I have to take instruction and let the matter posted on these next week on Tuesday.
Tuesday,
Yes, my lord.
Secretary 30. Yes,
We'll do, my lord, if you want.
let the matter be listed on Tuesday, that is 30, as it is submitted by the learned Standing Counsel Forest, Mr. D. Gogoi, that you'd like to place up-to-date instructions in the matter.
Last occasion, your lordship was pleased to call for the record.
Doesn't matter, let him get the,
Yes, will do.
let the matter be listed accordingly on Tuesday, 30. Mr.
Okay.
C.I. Barboia, I appeal for the petition.
Okay.
May it please your lordship. As per earlier direction of the honorable court, I place the ONGC self-contributory post-retirement and death in service benefit rules 1991.
Sorry, I didn't get you. What?
Lordship,
Pleadings are complete.
Feelings are
Yes,
complete. There are
yes.
some urgencies on our part.
What is
Because
the urgency?
my pension has been stopped by the LICI manner. Through the impugn letter issued on 13/4/2023.
Where is that?
Page 33, my lord.
33.
What happened, my lord? As per ONGC LIC agreement, my lord, the ONGC deposit an amount of some amount to the LICI, and LICI on the basis of that issue pays the monthly pension to the petitioner, my lord. Total amount was 54 lakhs with the LICI deposited by the ONGC. And during the earlier course round of litigation, my lord, the court allowed this court allowed to withdraw 1/3 of the amount, my lord, and accordingly 18 lakhs was paid to the petitioner from the principal amount of rupees 54 lakhs, my lord. And now presently 36 lakhs are with the LICI, 2/3 of the total amount. And they are supposed to pay the pension against that amount, my lord. It is about 20,461 per month from 1/4/2023. But they have stopped the pension, my lord, saying that as your earlier initial period since 17 to my lord, till the dwell of 1/3 amount, they want to recover, holding that the initial amount was 36 lakhs, my lord, and 54 lakhs, they want to take 10,000 back from the petitioner by way of recovery, my lord. It is around 7,26,170. That is put to challenge. And last occasion, this honorable court asked to produce the agreement, and there is no such agreement. They have not produced it, my lord. They have just produced the rule today. I have given to me one copy, and in that rule there is no such provision for issuing such types of orders. Rule says simply, my lord, is the 1/3 can be withdrawn, my lord, out of the total annuity amount. That is there on. It is not there that the after withdrawal of the 1/3 amount, it has to be recovered the amount received by the petitioner against the total amount. There is no such provision like that in the rule, madam. I have read it.
That is in rule 13Q here, clause 13, subclause 2. I have already highlighted here, marking also.
Yes.
Here it says, subclause 13(2), no beneficiary shall have any interest in any insurance policy taken out by the trustee under the rules of the fund, and he shall be entitled only to an annuity from the fund. Lordships, initially the petitioner took the option.
Where is the earlier order of the court?
It is there,
Yeah, page
28, madam. It's the operative postal, madam, page number 30. They agreed in the earlier round of case to withdraw, my lord, the 1/3, and at that point of time, they have never expressed such condition that would be imposed upon the petitioner in the event of withdrawal.
Lordship, in my affidavit in opposition, 48 page.
You are appearing for whom?
LIC.
LIC. Have you seen the order 30, page number 30? It begins at 29.
Yes.
You come to page number 30, fourth paragraph. Read the paragraph.
If them.
If that is so, I am of the view that nothing further survives for adjudication in this writ petition with the consent of the learned counsel for the parties. This writ petition is therefore disposed of by granting 10 days time to the petitioner to make appropriate application before the LICI authorities by making a copy to the respondent number 2. On receipt of such application, the LICI authorities may process the same and take appropriate decision for release of up to 1/3 of the amount to the petitioner for his personal use by retaining the balance 1/2. So,
So you were directed to take a decision for allowing 1/3.
accordingly, is complied by this LICI.
How?
Honor the order of this honorable court by the LICI, but excess amount taken received by the petitioner, LICI served demand notice just to recover the said excess amount, which is payable.
What excess amount means? How is it excess?
Excess amount, he petitioner purchased the annuity
Hmm.
by total purpose of rupees 54 lakhs.
By transferring his entire
Entire amount.
amount.
Yes. And the
What is the value of the amount? What is the value of the annuity?
monthly annuity is 30,000. 30,000.
No. What is the entire amount that he has transferred?
54 lakhs.
54 lakh. What is 1/3 of 54 lakhs?
No, it is come later on. Initially, we purchased the annuity by utilizing the amount of 54 lakhs. And monthly pension get 30,000. Thereafter, he approached before this honorable court to change the option, which was not changeable. The option, Lordship's, in my affidavit in opposition.
No, you come to the letter, impugned letter at page 33. Page 33 letter. This is the letter issued by LIC, isn't it?
Yes. Page 33.
Yes, 33.
This 33 letter, second paragraph, you are authorized by your central office to recover the difference of annuity amount.
Annuity amount. Yes.
What is the difference? How the difference occurred?
Difference amount is 7,26,170. 7,26,170.
How did it happen?
It is happened because the annuity that is 30,000 in each and agreement he got received, and later on, while the option change and opted by the petitioner in changing 1/3 purpose value. So in 1/3 purpose value, he received the monthly pension 20,000. 20,000. But it is a purchase. The policy was purchased. Initial.
Then why don't you adjust it with the balance amount? You adjust it with the balance amount. Why are you withholding the entire amount? Whatever according to you.
Kindly, this honorable court may direct to the to refund the said excess amount and
No. Refund. Why? Where is the question of refund?
excess.
According to you, he has taken away some amount.
Yes.
Which according to you, he should refund.
Yes.
But you are also entitled to give him some amount towards annuity. So from that annuity, whatever amount according to you he has drawn or received in excess, you adjust it. Why are you asking for a refund?
Yes.
Can it not be done?
Yes.
Then?
My lord, our submission is that, my lord, the period when I received the 30,000, my lord, during that period, they have retained 54 lakhs. And that now, my lord, it has become 36 lakhs, against which 20,000 has been sanctioned, my lord. That is there.
We are not here to decide the arithmetic. You work out whatever is payable or receivable and sort out the problem. They are agreeable to adjust the amount which according to you have received in excess and which they had sought for a refund.
Excess, my lord, they are saying that they are assuming, my lord, total amount is 36 lakhs from the day of my superannuation. And therefore, they have come to the conclusion that I have drawn the excess amount. That is their meaning of the impugn letter, my lord. But in fact, my lord, I have received the 30,000 against the 54 lakhs. They are retained for that only, for that period only.
It's not clear.
I'm explaining, my lord. I retired, my lord, on 31st March 2017. On from 1/4/2017, my pension started.
Right.
Against, my lord, 54 lakhs money deposited by the ONGC with the LIC. And, my lord, I continued till March 2023 with the 54 lakhs money, and I received 30,000 per month. Now they have, due to the litigation, my lord, they have paid me 1/3. Now the money has reduced to a 36 lakh. Now I'm receivable, my lord, 20,000 per month. Now they are saying, my lord, they are assuming that I have 36 lakhs of, from the day of my superannuation. And they are assuming my pension as 20,000 from the day of superannuation. Which,
right. So naturally they have overpaid you.
But my submission is that the amount they have retained for that period, my lord, against that amount they have paid to me.
No, how can it be? You calculate and show. 54 lakhs, they had calculated annuities of 30,000. You have been receiving. Then you come to court, you say that this option was not given to me, I want to give this option. You apply the option. They agree and they allow that 1/3. Subject to that 1/3 will be of 1/3 of the original amount.
Yes.
But the original amount, 30,000 per month, you have received for some years.
Yes.
So from that original amount, if they pay you 1/3, they pay you 1/3.
Yeah, they paid already.
Then the calculation ought to have been 20,000 or whatever on 36,000 from the date you have retired. But you have received 10,000 extra.
Yes.
In excess.
But the agreement, my lord, there is no such agreement like that, my lord.
No,
and
but-
the rule also does not specifically say.
It is you who have prayed for it, 1/3.
Yes, I have paid for 1/3, my lord. From the day they have given me 1/3, the 20.
Have you received 1/3?
Yes, I have received.
You received 1/3.
From the day they have given me 1/3 and they reduced the amount, my lord. From that day, my pension will be reduced, my lord.
No, that 1/3 is the 1/3 of the total amount. You are asking 1/3 of the total amount.
Yes, total amount.
So the annuity was calculated on the total amount.
Yes.
And if you take 1/3 away, that annuity will be calculated on the basis of the total amount minus 1/3.
Minus 1/3, my lord.
So that how can that 1/3 be calculated on the date you have received it? It will have to relate back to the original date.
Now they are asking for 7 lakhs refund by me, my lord.
So don't refund. They are agreeable to adjust it.
Your lordship may have the monthly basis, my lord.
On monthly basis. Heard learned counsel for the party. Yes, you want to say something?
Lordship,
You want to say something?
yes, Lordship.
Regarding gratuity,
Regarding Lordship, petitioner have filed affidavit in reply. And in this affidavit reply, para 6, page number 74. Lordship, that page number 6, 74, 6.
Hmm.
That as regard to the statement in para 5 of the affidavit in opposition filed by ONGC, the deponent begs to state that ONGC authority has the knowledge that an amount of 10 lakh is payable on account of gratuity accrued to the petitioner during his service period, but till date, the same has not been credited to the account of petitioner. But but already gratuity of 10 lakhs in 2017 and 10 lakhs in 2018 already have paid, Lordship. This is the copy.
Then why have you not brought it by way of an affidavit instead of submitting copies here?
they have
you
not
given
served
him a
the copy
copy?
to us also.
Have you given him a copy?
No.
Then
Recently, but we have already paid.
no, but you should have given him a copy earlier. What is this? Second page?
Second was Lord's
Earnings, deductions and all that. Pay slip. You have given the pay slip.
yes, pay slip.
So what does it indicate?
In the second page, the gratuity on separation 10 lakh. Lordship, in the column earning. Second page earning.
Hmm.
Gratuity on separation 10 lakh. It was paid in the month of February, Lordship. Lordship, the petitioner retired on 28/2/2017, but before his retirement on 2001/2017 by Annexure 2B.
Okay. You have received the gratuity.
Then
Heard learned counsel to the party. This petitioner is before the court, praying for. Setting aside and quashing the communication dated 13/4/2023, issued by the LICI respondent number 6, with a further prayer to direct the LICI authority to continue to pay the monthly installment at the rate of rupees 20,461 per month to the petitioner with effect from 1/4/2023. Para the petitioner, the short case of the petitioner is that he was employed under the ONGC, and in terms of a scheme available with the ONGC and the LIC, in terms of a scheme of the ONGC with the LIC, comma, the employees are given the option to purchase annuities from the LIC on the amount to be deposited by the ONGC, and thereafter they receive monthly annuities after their retirement. Stop. The petitioner, the the ONGC deposited rupees 54,08,215.64 in so far as the petitioner is concerned to the LIC under the post-retirement benefit scheme. Stop. The petitioner superannuated on
31/3/2017.
31/3/2017, and from 1/4/2023, petitioner has been receiving the annuities under the post-retirement benefit scheme.
1/4/2017, my lord.
2017. He has received the benefit under the post-retirement benefit scheme. He has received the annuities. Annuities received are at the rate of rupees 30,688 per month. So, subsequently, the petitioner came to be aware that there was an option available to the petitioner to withdraw 1/3 of the amount deposited to the LIC and receive the balance on annuity. So, since this clause was not made known to the writ petitioner, he approached this court by filing a writ petition being WPC number 913 of 2018. Stop. This writ petition came to be disposed of by the coordinate bench by the order dated 16/2/2023. Stop. This court, on the submissions made by the councils before the court and on the consent, passed a consent order disposing of the writ petition, granting 10 days time to the petitioner to make appropriate application before the LICI authorities by marking a copy to the ONGC. And upon receipt of such application, the LICI authorities will process the same and take appropriate decision for release up to 1/3 of the amount to the petitioner for his personal use by retaining the balance 2/3. Stop. Pursuant to the disposal of the writ petitioner, the petitioner filed necessary application before the LICI with a copy to the ONGC. Stop. The LICI, in response to the application filed, issued the impugned letter dated 13/4/2023. By the said letter, the LICI requested the petitioner to refund the excess amount drawn by way of annuity amounting to rupees 726,117 in order to release the revised annuity payable to the petitioner. Stop. It is this communication which has been challenged before the writ court with a further direction that since the issuance of this letter, the annuity has been stopped and stopped. That apart, it is the further claim of the writ petitioner against the OMC that his gratuity had not been withdrawn. The LIC has filed their affidavit disputing the claim of the. You have filed affidavit
Yes.
disputing the claims of the petitioner and stating that uh, since the annuity since the 1/3 amount is required to be released to the petitioner, the excess amount drawn by way of annuity is to be refunded to the LIC in order to enable them to release the annuity as per the revised rate. Stop. The ONGC also contested the matter, stating that the petitioner has been receiving the annuities as per the uh, scheme, and pursuant to the order dated so and so passed by the High Court, the application for revised rate has been filed, and the LICI authorities have agreed to release one third, subject to release of the excess amount drawn as annuity. So, although not a part of, although it is not pleaded in the counter affidavit filed by the ONGC, during the course of the hearing, learned counsel for the ONGC has placed before the court relevant documents to submit that the claim of gratuity made by the writ petitioner is also uh, unwarranted, as the amount of gratuity has already been released. What is the amount released? 10 lakh.
10 lakh.
10 lakhs. 10 lakhs gratuity has already been released.
2018, Lord.
As far as in 2018. So, the payment of gratuity slip in respect to the writ petitioner has been placed before the court, which is kept as a part of the case record. Stop.
20 lakhs. 20 lakhs.
Learned counsel for the parties have been heard, pleadings on record.
Lordship, 20 lakhs gratuity was paid to him. In 2017, 10 lakhs was paid, and after subsequently on 27/10/2017, there was a pay revision, which was made effective from 1/1/2017, and after that, 10 lakhs, which was also paid to the petitioner on 30/4/2018.
Where is that?
Lordship, that.
This is only 2018, 34. Okay. First amount was released when?
In the month of February 2017.
Okay, you're right. Gratuity was released originally on in the month of February 2017 to an amount of rupees 10 lakhs.
No, Lordship. 10 lakhs plus 13 lakhs 34,685.
13 lakhs 34,685. So subsequently, there was a revision undertaken, and on 30/04/2018, further amount of rupees 10 lakhs was released to the petitioner. Stop. Having heard the rival arguments, submissions, and also upon careful perusal of the pleadings on report, this court is of the view that the issue raised in the petition is within a narrow, very narrow campus. Stop. While it is correct that the petitioner has been permitted to withdraw one third amount, and the annuity, and prior to that, in terms of the post-retirement benefit scheme, the petitioner has been receiving the annuity at the rate of rupees 20,000.
30,000, madam.
668.
688.
688. So, comma. However, the step taken by the LIC cannot be faulted with, in view of the fact that after release of one third amount, the annuity which is to be calculated will have to be in respect of uh, the amount which the petitioner had been receiving since the inception. Stop. Under such circumstances, the LICI is within its rights to verify and pass and take necessary steps for adjustment or recovery of the excess amount paid. So, however, the grievance of the petitioner is that for pursuant to release of the one third amount of the by the LIC for continued release of the annuity at the revised rate. The LICI has requested the petitioner to refund the excess amount at the rate of 726,117 so that the annuity can be released. Stop. As on date, as the petitioner did not refund the amount of 726,117, the revised annuity has not been released, and the petitioner is without any pensionary benefit in terms of the post-retirement scheme. Stop. This court is of the view that the LICI, if the LICI has arrived at a finding of the petition of the necessity to recover excess amount, then the same can always be undertaken by making by recovering the same by making necessary adjustments from the annuities that is to be released to the petitioner monthly. Stop. As such, instead of demanding a refund of rupees 726,117, the LIC authorities are at liberty to adjust this amount towards the monthly annuity on a monthly basis.
25%, my lord, per month. 25% of the total amount.
We don't know.
Otherwise, my lord,
At the rate of 30% from the annuity. Stop. This excess amount, the monthly annuity will be released after deduction of the
30%.
excess amount at the rate of 30%, not greater than the rate of 30% from the monthly annuity till such amount has been properly adjusted. Stop. With the above observation, the petition accordingly stands disposed of.
And the area
The-
pension will be
the, the the release of the monthly annuity after deduction of the excess amount at the rate of 30% will be carried out, and the impugned communication dated so and so will be no bar, will act as no bar in compliance with the order as directed upon. And what is there?
my lord, area pension that with effect from my lord 1/4/2023 may
The
be
area
released.
pension with effect from
1/4/2023, my lord.
1/4/2023 shall also be released after making necessary adjustment. So, it is also recorded that the petitioner has already received his gratuity and no further claim survived. With the above observation, writ petition stands disposed of in terms of the above. No order is proposed.
Obliged.
Number 12. Yes,
Definitely, Lord.
yes, yes.
My lord, this case is relating to payment of career benefit, your lordship, of the husband of the petitioner, your lordship. And the honorable court's order, your lord. The page. Page 66, your lordship. 66 and 67. 67,
Yes.
manual lordship, para 23, your lordship.
Hmm.
Para 23, your lordship will find. In view of the above, both declaration of the petitioner suspend Sumit Chandra Bordoloi as deserter and his dismissal from service, I order dated 31st/8/2005 are set aside, and qua he shall be treated to have been in service till his death on 19/8/2004. The period from 4/5/2000 till 19/8/2004 shall be regularized by the authority. Consequently, Srimati Baijanti Bordoloi, widow of Sumit Chandra Bordoloi, shall be entitled to all consequential benefits due to late Sumit Chandra Bordoloi. All such benefits shall be released to her within a period of 3 months from the date of receipt of a certified copy of this order. Then 24, your paragraph, for the pain and agony that a helpless widow had to undergo while pursuing the litigation for all these years, court is of the view that cost of rupees 25,000 should be paid to her by the respondent along with the service benefit within the period as indicated above. As such, the petition is allowed. That period, your lordship, the out of 3 benefits, your lordship, the petitioner has received 2 benefits. Only that period, your lordship, the period from 4/5/2000 till 19/8/2004
Yes.
shall be regularized by the authority, and that period, regularized period, the Honorable Court directed directly that that period from Iman should be regularized by the authority as well as that should be paid, your lord. But that benefit till today they have not paid, your lordship. Hence this writ petition, your lordship. Then your lordship will
You did not file a contempt.
Thereafter I have filed a contempt.
Then what happened?
That in contempt, your lordship, in contempt petition, the Honorable Court closed the contempt petition with a direct, with a liberty, your lordship, to file a fresh litigation, your lordship, adjudicate the order, your lordship. Your lordship will find the contempt case order, your lordship, page 96, your lordship. May read the whole order, your lordship.
No, not necessary.
Well,
Whether the direction to regularize will include direction to pay salary. That is the question.
That is the question.
my lord.
Now, for what purpose was the what is the effect or consequence of a service being regularized?
Unless regularized, lordship is, the husband of the will not get the pension, lordship. Now, in this case, we have followed the provision of Rule 25 of the CCS LIB rules.
No.
Lordship.
Yeah,
Let him submit, lordship.
no. That did, nowhere is written here. So in the order, you will observe it is clear.
Have you received pension?
Arrear pension, more than
pension
10
has
lakhs
been
has been
arrear pension.
Now she is getting
everything
regular pension.
Received, but except that period. Honorable Court directed directly, your lordship. There is no any that Honorable Court did not say anything regarding
What are you supposed to receive? The salary.
Salary.
salary, your lordship. Salary from the period
There is no
arrear
direction.
benefit salary, your lordship, from the
There is no
period,
direction.
my lord.
There is no direction.
Direction, your lordship.
There is no direction to release the salary.
No, no, sir. Service benefit, your lordship will find Honorable Court's direction clearly stated, your lordship, that page 67, your lordship, 67, in view of the above, both declaration of the petitioner husband, Somet Chandra Bordoloi as deserter and dismissal. Firstly, he was declared deserter, then even dismissal thereafter. After death of the employee, your lordship, they dismiss him, your lordship. Then from service, height order dated iman are set aside. All the orders, your lordship, deserter as well as dismissal set aside. He shall be treated to have been in service. Then what does it mean? I don't understand, your lordship. He shall be treated to have been in service.
Yeah.
The Honorable Court clearly stated.
See, an order of the court is not to be interpreted like a statute. Order of the court is to be read and understood what it means.
My lord.
So your consequential benefits.
My lord.
It did not say consequential service benefits. It did not say consequential pensionary benefits. It says consequential benefits. What is consequential benefit?
Consequential, whatever he has not received, your lordship.
So
He went to join in the duty, your lordship.
no.
But they played away him, your lordship. They not paid in heed regarding his after availing his leave, your lordship, casual leave as well as medical leave. May I convince your lordship? Your lordship will find.
Now, are you relying on any judgments in support of your contention?
My lord, judgment, your lord, judgment. I have some judgment, your lordship.
You give the list, please. You give us a list of judgments you want to rely on. We'll have to take out copies.
These has already been
Given. List detail. So judgment will have to have copy recently. Huh? No.
Then your lordship will find 2014 1 GLR, page 730, your lordship, para 11. Para 11. May I read it? In my judgment, the aforesaid findings of the tribunal do not suffer from any infirmity. In the contrary, those findings are based on evidence that respondent number one was admittedly suffering from rheumatic fever and had undergone treatment at the departmental hospital of Kashar Paper Mill from so and so, for which he sent leave application to the management HPC, and after recovering from his ailment, he visited his office with medical fitness certificate, but he was not allowed to join in his service. Then one thing leads to another, where after the impugn order of removal was issued, in my judgment, the absence of the respondent from duty under the aforesaid proof fact cannot be held to be willful. His absence is not willful, your lord. Due to his ailment, your lordship, he was go on leave, your lordship. Thereafter, as well as after that, your lordship, he expired, your lordship. expired during during the pendency of the writ petition, Your Lord, held to be willful or abandonment of service. His absence was rather due to illness and therefore occasioned by circumstances beyond his control. The tribunal did not commit any error of law or jurisdictional error in deciding the case against the petitioner corporation. The next question to be determined as to whether the petitioner is entitled to back wages. A number of decisions have been cited at the bar by the council appearing for the rival parties. Suffice to it to say that the principle of no work, no pay cannot entirely apply in this case, inasmuch as respondent was wrongly removed from his service, as indicated earlier. Nevertheless, and on considering the totality of the facts in this case and also of the difficulty being faced by the petitioner corporation, it will not be equitable to saddle them with the entire back wages either. Under the circumstances, by striking a balance of between the interest of the corporation and the respondent number one, I decide to give back wages to the respondent number one only with effect from the date of transfer when the impure awards were passed by the tribunal. Then here got the all area benefit, Your Lordship, consequential benefit, Your Lordship, as is in as his absence is not voluntary, Your Lordship.
Yes.
Hence, Your Lordship, he may be allowed to draw the back wages, Your Lordship.
Yes. What do you say, Mr.
Lordship.
Proper-
Lordship, in this case, the husband of the petitioner was on leave from 5/5/2000 to 9/5/2000. He never reported. So thereafter proceeding was done. He was declared deserter, and thereafter he approached only in 2002, filing the writ petitions. Finally, that has been allowed. There is no dispute to that regard.
What has been allowed? Let us examine para 23.
Lordship.
One thing, Your Lordship, they have filed appeal. That appeal was dismissed, Your Lordship. Yes, in my writ petition is your last, Your Lordship. In page 99, Your Lordship. Page 99. In absence of me, Your Lordship, petitioners, they filed a writ appeal, and that writ appeal was summarily rejected by the Honorable Court, Your Lordship. Page 101, Your Lordship.
Yes. Kindly come to page 101 of the appellate order.
Ma'am.
Lordship, I've seen that. But Lordship has also has to look into the page 96. That was subsequent to the rate appeal, Lordship.
Yes.
Page 96. We have paid 10
The contempt.
contempt. More than 10 lakhs
But
paid as a
it can't explain a division bench order.
Lordship. That's true, but there are also no clear-cut direction that he'll be entitled to the back
that
wages
is
for
what
the
I
whole
want-
period.
No, that is what I want to tell you.
Lordship.
You first read para 23 of the judgment, page
23.
67.
Lordship. In view of the above, the both declaration of petitioner's husband Samit Chandra Borda as deserter and his dismissal from service by order dated so and so are set aside in course. He shall be treated to have been in service till his death on 19/8/2004. That is the date when we expired, Lordship. The period from 4/5/2000 till shall be regularized by the authority. Consequently, Srimati so and so shall be entitled to all consequential benefits due to late Samit Chandra Borda. All such benefits shall be released so and so. So all these consequential benefit will also include the salary or not, Lordship. That is need to be interpreted, Lordship.
That's
Now,
what I'm saying. It says
Lordship.
entitled to all consequential benefits.
Well,
Now,
there is
now you come to page 101,
Lordship.
last paragraph.
Lordship, from in the fact.
Yes.
In the fact situation of the case, we find ourselves in complete agreement with the view taken by the land single judge. Must now immediately release all the consequential service benefit. It's also said the same consequential, but what should be the consequential?
No. There's a difference.
Lordship.
Single bench said all consequential benefit.
Lordship.
Division bench said all consequential service benefit. In an appeal filed by you.
Lordship. Lordship.
Service benefit means service benefit.
Lordship. Lordship, may kindly look into the provision of Rule 25 of the CCS leave rule.
No, why we look into it? This is the finding of a division bench in an appeal filed by you.
Lordship, that's true.
No further appeal.
No further review.
No review. You have accepted the consequential service benefit. Single judge said consequential benefit.
There has to be, in my respective solution, there has to be a specific direction for salary, for area salary.
No. That judgment which you are relying on is a judgment under the labor law.
Lordship. That Lordship is Gen Manager Haryana versus Udham Singh.
Yes, that is on a labor law. That under 25, merely because your termination is found to be unjust, does not automatically lead to payment of area wages. Here is the case where he was on leave and declared to be a deserter. That was set aside. He was entitled to leave. It is not a case of unauthorized leave. For assuming it is, and he was declared to be a deserter, that is order itself was set aside. He shall be treated to have been in service till his death. Yes.
Lordship, may kindly look into paragraph 29 of this judgment.
Which judgment? Which judgment?
Supreme Court judgment.
No. You have punished.
Perhaps not. Paragraph 29, the last few lines, Lordship. On the principle of no work and no pay, Lordship. And one has to show that not gainfully employed.
No work, no pay.
And during that period, he has not gainfully employed.
That is under labor law.
Lordship,
Where will a person be gainfully employed? What evidence do you have for a gainful employment? Paragraph
29, last few lines of that. Lordship, may tell you on Rule 25 of the leave, CCS leave rule, Lordship.
We are talking about the facts of the case. You had filed an appeal. The appeal was turned down. No further appeal. And while disposing it of, the division bench said all consequential service benefit.
Whether that service benefit will include the salary.
What else? What else? Tell me.
Other pension and all, Lordship.
Pension is pensionary benefit, not service benefit. What benefit, what service benefits do you contemplate under the term service benefit?
Lordship, that revision of pay on all that's incremental.
Pay for what?
That can be calculated, but not the salary.
Why not?
Because on the principle of no work, no pay. Lordship.
Where is the principle of no work, no way, and no pay applicable here? When the order of being declared a deserter has been set aside. Has been set aside. And there is a specific direction, he shall be treated to be in service till his death. What is the meaning of treated to be in service?
As that there can be, Lordship, certain percentage only, Lordship.
No.
Not full
No.
salary, Lordship.
It
Lordship,
has to be very.
Lordship may
it has
keep
to
the
be
matter as a
dependent
part.
on facts and circumstances
Lordship
of
may keep
the
the
case.
matter as a part. Let me come satisfy on that regard, Lordship.
We are tired of keeping things parted. When a matter is listed, if you want time, you pray for time. Otherwise, you get ready for hearing.
Now, to that extent, that whether it will be full or half salary, Lordship.
Hard in part, matter be listed on 16
Lordship.
May.
Please, I pay for timing, Lordship. And
Typing today at 3 o'clock, typing.
And item number 14, just additional affidavit has been filed yesterday, Lordship. That also may not the record.
That is of no relevance for the first.
That is no relevance
For the first case.
There will be a delay.
Where is Mr. Dotto?
Another report, Lord.
Mr. Ahmed, he is not here. We are keeping it aside for the time being. Let us see. If he comes, we'll take it up. If he comes, we'll take it up.
May I please the Lordship?
Yes.
My Lord, today the Lordship is fixed for my Lord, for final hearing, my Lord. Here in this case, my Lord, present petitioner, he was the headmaster, my Lord, in charge headmaster, and he was one complaint laws on 9/6/23 by the respondent number 7, my Lord. He was the president of that concerned SM School Managing Committee. And regarding that misappropriation in the midday meal, as well as my Lord, some sports 24,000. There's some sports fund is not utilized. That is this complaint against him. Then my inspector of school respondent number 5 conducted inquiry in this case. Here, my Lord, your Lordship will find. I'll take your Lordship. The one complaint, 3 inquiry reports by the 3 different officers on same the replica of the first inquiry reports, all the subsequent reports, and 2 hearing conducted. First hearing conducted on 6/10/2020 by the director, as per the first inquiry report.
What is your status now?
My Lord, as is during pendings of the matter, they have initiated in the proceeding against me. So it was issued to me. I filed reply. Event hearing also done, my Lord.
You are now on the suspension.
Yes, my Lord.
Is there a review done for the suspension?
My Lord, 19/4/23 hearing is done, my Lord. But what till date they have not given findings of the hearing is yet they have not placed, my Lord, to me, my Lord. At this my humble submission in this case, my Lord, the Lordship will find all the I am against the procedure they initiated in the inquiry report. Absolutely incorrect inquiry report they have placed, Lord. Relied by the incorrect inquiry reports and been placed under suspension, my Lord. And though 2 times hearing done, my Lord.
You
For
are
one complaint, my Lord.
You are placed under suspension after an inquiry.
Yes, my Lord.
And then again another disciplinary inquiry.
Yes, my Lord. During pending of the petition, the proceeding initiated, my Lord. So court issued to me, my Lord. I also filed reply, hearing concluded, but no outcome yet, my Lord.
Where is the inquiry report?
My Lord, yes. Lordship, here in this case, my Lord, I filed one additional affidavit. There are 3 inquiry reports I have enclosed. Kindly, my Lord, my additional affidavit may be taken, my Lord. Before taking to read petition, my lord.
Yes.
Lordship, kindly have a look on first inquiry report, page 86, annexure E. Sorry, page 87, my lord. Annexure F. It is on 24/7/2023, my lord. This inquiry has been conducted, my lord, Inspector of School, respondent number 5. Lordship will find, as per the complaint received from the president, that is respondent number 7, my lord, member of so-and-so, Balikuri, so-and-so, with the undersigned had visited the Balikuri Anchalik Panchayat on 28/6/23 at 1 p.m. And regarding the various allegations against the in-charge headmaster of the said school, and accordingly we have inquired and found followings, my lord. 1. The in-charge headmaster was charged very poor and less MDM to the students as per the written statement of the student president and member bench. Number 2. The in-charge headmaster was not charged egg on the Wednesday as per the schedule and deprived the students from MDM Saturday as per the written statement. Number 3. As per written statement of the student, it is ensured that the headmaster was therein different types of fear. My lord, the 4, 5, and 6 I'm concerned with. 4. As per the allegations, the headmaster was collected the rice from Somabai on 15 March 2023, but the rice was not taken into the stock room and he was returned the stock register on so-and-so 11.72 kg rice was received. The ending was not served in the month of March 23 due to examination. Number 5, the allegations, the stock register MDM scheme shown that the opening balance of the rice so-and-so kg on May 23. The rice was again received 1 quintal on the same month. The total balance of 9.59 kg and the consumption during the month of so-and-so gram and closing balance, my lord, this is important, 2.11 gram. But when we undersigned was visited on the school on 28/6/2023, it was seen that 20 to 25 kg rice was available in the stock, my lord. Number 6, my lord. The headmaster was released the fund of the annual grant, sports grant, eco club, etc. for the financial year 2022-23 to the vendor accounts. He also stated that the said vendor has received and when the undersigned was visited the school, there was not seen anything at the school. The headmaster was not purchased and utilized the above mentioned grant 2020. Basically, Milo 4, 5, and 6. First of all, in 4, Milo, they have said that.
What is wrong? What is wrong here?
Yes, I will come. All answers I have all in my reply. I have submitted below. In serial number 4, Milo, they have said that and MDM was not served in the month of March due to exam. Absolutely incorrect, wrong statement, my lord. There is no examination in the month of March. There is examination in February, my lord. If the inquiry is genuinely conducted, why they have given the wrong information that examination in the month of March? Second, my lord, that I'll take a lordship.
Is there any review of your suspension?
No, Milord, no review. I have not gone for the review, Milord.
Well,
and since hearing has been done, Milord, and till date, Milord, hearing concluded, Milord.
What are you challenging here in the writ petition?
Suspension order.
Suspension order.
Yes, Milord.
So that suspension order.
The suspension order means, Milord, the process they have initiated.
What are the principles for interference of?
No, Milord. I'm not on that, Milord. They relied on incorrect inquiry reports, Milord. I'm being suspended, Milord.
What material is before the court to decide that what you are saying is correct and what
Milord, all the materials, Milord, what are subsequent developing in this case, I have all the documents, reports, I have enclosed in my additional affidavits.
First, you tell us what are the principles of judicial review for interference in a suspension.
My lord, this court, there's this interfere, my lord. If the proceeding is the suspension is not a punishment, this is your lordship, but I'm also aware, my lord. But here in this case, a person, innocent person being placed by incorrect, submitting incorrect reports, and I'm being placed suspension. It is to be interfered.
Therefore, a review is necessary. Whether further suspension is required or not, it is for the authority to take stock of the things and decide whether these continued suspension is required.
Hearing complete, my lord. They let them, my lord. What the outcome of the hearing, my lord. Maybe given within a week, my lord. If they fail to give me the outcome of the hearing, 2 times hearing done, my lord.
What hearing?
Against the inquiry report, my lord. They proceeded departmental proceeding against me and hearing done, my lord.
Proceeding is not under challenge here. Is it under challenge here?
No, we are not challenging since during pendency they have initiated this process, my lord.
So that is not under challenge. What is under challenge is the suspension, isn't it? What are you challenging here?
Suspension.
You are challenging the suspension because it is supposed to be based on wrong facts and
Yes,
wrong
my lord.
material.
Yes, my lord.
Now, on what basis will the court decide whether your submissions are correct or not? Where is the material?
My lord, since my lord, the government has not filed any affidavit, my lord. So
That
I
is not a
also file
ground
all these
to
things, my
presume.
lord. And
That is
my
not a
my
ground to presume.
my humble submission, my lord. Admittedly, my lord, they one
Why
one
don't
complaint,
we-
my lord.
Why don't we direct the respondents to take a call on your suspension, undertake a review, and decide whether further suspension is necessary or not?
Yes, my lord. Yes, lordship.
That can be done.
Yes, lordship.
Yes.
Because he was suspended on 16 to 2024.
So,
Lordship, Lordship
So,
will
3 months.
review the suspension
Huh?
and under Rule 14, your Lordship of the Assam, you can always file an appeal, your Lordship, against
That is okay, but then you have to also take a review.
Lordship.
To undertake the review,
Lordship, we still have time.
whatever time is there, you take a review. Call for a review. You also have as correctly pointed out, you also have a alternative remedy of filing an appeal under Section 14.
It is true, my lord. There is a provision, my
So,
lord.
would you like to file an appeal?
My lord, I will take by this process. Will I will, my lord, suspension will continue, my lord. That is so lordship is offered a review. It is better way, my lord, so that the entire matter may be.
Lordship, when the hearing is not completed,
What hearing?
the disciplinary proceeding.
He is not challenging disciplinary proceeding. He is challenging.
It is not under challenge.
He is challenging the suspension.
Time bound may be given to review, my lord, to conclude, my lord.
Third, learned counsel for the parties. This writ petition is filed by the petitioner who was serving as the in-charge headmaster of Balikuri Ancholik High School, Borpeta. So the petitioner during his service was placed under suspension by which order?
My lord, page 61 writ petition, annexure 12, 16 to 24.
Placed under suspension. Page number?
61, my lord.
By the impugned order dated 16/2/2024, issued by the Director Secondary Education. Stop. By the said order, pending drawal of departmental proceedings, the petitioner as assistant teacher and headmaster in charge of Balikuri Ancholik High School District, Borpeta, was placed under suspension as per provisions of Rule 6 within bracket 1 of the Assam Services Discipline and Appeal Rules 1964. Stop. During his period of suspension, petitioner is entitled to be issued subsistence allowance. Stop. The learned counsel for the petitioner submits that a preliminary inquiry was undertaken and by the inspector of schools, and on this on the basis of the inquiry, not based on correct facts, the petitioner was placed under suspension. Learned counsel has referred to the inquiry report at page number.
My lord, 3 inquiry reports I placed, my lord. Page 87, 86, and 85.
87.
86, 85. 3 inquiry reports.
Submits that there were as many as 3 inquiries conducted.
24/7/23, first inquiry, my lord.
The first inquiry was conducted on 24/07/2023.
Second, my lord, 6/10/23.
The second on 6/10. Where is that?
23,
6/10.
23.
Where is that?
Annexure, sorry, in my additional FE, annexure D, page 85.
On 6/10/2023, which was also conducted by the inspector of schools. And the third?
86. Next page, annexure E. That is on 13 to 24.
Also was conducted by the district accounts officer, block accountant, senior assistant, and the PSO in the inspector of schools office. Stop. By these inquiries made, several allegations were made against the petitioner, including financial irregularities, and a consequence thereof, the petitioner was placed under suspension. Stop. Petitioner is presently under suspension, and no review as yet for continuation of the suspension has been undertaken by the respondent authority. Stop. It is further submitted by the learned counsel to the petitioner that department proceeding has been initiated by issuance of a show cause notice dated
So cause notice
28 to 20.
28 to 24.
28 to 2024.
Annexure A, my lord, in additional affidavit.
Stop. In response to the show cause notice, the
I also filed reply.
petitioner had filed its reply. Stop.
So 28.
The respondents, you're right, the petitioner's counsel submits that these allegations are false, concocted, and not based on facts, and the petitioner is a victim of a conspiracy by his adversaries, and this order is totally order of suspension is totally uncalled for. Therefore, the learned counsel urges that this impugned order of suspension be set aside and interfered and quashed. So, the respondents represented by the State Council submits that no affidavit has been filed as on date. Are you representing someone?
I'm for the respondent number 7, Lordship.
Who is 7?
7, Lordship, President, Lordship of the.
Have you also any affidavits filed?
Today I have filed, Lordship.
You filed?
Today, Lord.
Served a copy?
My lord, in affidavit, they have said they have already released their from the post of president, my lord. They have already, in the paragraph 33, they have said that.
Released?
No, Lordship.
My lord, they have said that.
Handed over this.
Handed over. That means he is no more president, my lord.
The respondent, Mr. So-and-so, learned counsel, appearing on behalf of respondent 7, has filed an affidavit stating that he is no longer the president of the School Management and Development Committee of Palikuri Ancholi High School. Having heard learned counsel for the parties,
Lordship, another submission, Lordship. Their basic allegation against me that I have filed false complaint, Lordship. That is I denied, Lord.
Learned counsel for the respondent number 7 further submits that the allegation made against the respondent 7 that he has filed a false complaint is denied. So, having heard learned counsel for the parties and upon careful perusal of the readings on court, this court is of a considered view that since the suspension order was issued on 16/2/2024, and in the meantime, the departmental proceedings have already been initiated by issuance of a show cause notice, to which the petitioner has also filed a reply. It would be more appropriate for the authorities to decide to hold a review and decide whether further continuation of the suspension of the writ petitioner is necessary or not. So, as such, this writ petition is closed with a direction to the respondents, namely the Director of Secondary Education, to undertake the process of a review to decide whether the further continued suspension of the writ petitioner is called for. Stop. If any decision to that effect is taken for continuation of suspension, then a copy thereof shall be served on the writ petitioner. Stop. It is also directed that the disciplinary proceeding initiated against the writ petitioner should also be expeditiously carried on and concluded by passing necessary orders. Stop. With the above observation, writ petition stands disposed of.
Only one submission, or if they some time bound correction may be given. If they fail to
The
take other
review as directed should be uh, when does 3 months expire?
16 May, my lord.
May, Your
16 May. Review be concluded by review be conducted by 16th of May,
May
2024.
After they may if they have nothing found, they may for instead
In the event the authorities find that further continuation of the suspension is not required, the petitioner will be reinstated in service.
Deeply
with all
obliged.
service benefits.
deeply of.
I'm sorry, madam, I was not there. This item 13 and 14, my lord. 13 relates to, my lord, the petitioner was transferred from Namrup to, my lord, Bhubaneswar, my lord. And the other item, my lord, 14, my lord, it's regarding, my lord, he was asked to produce some original documents, my lord, and which we approached this court, my lord, and there is an order by this court that no coercive action should be taken, my lord. After passing that order, my lord, this transfer order was issued. And in that case, my lord, I have filed one affidavit also, my lord. During the pendency of this case, my lord, the respondent authorities again insisted me to produce all those documents. Now, if your lordship sees the order dated 18/9/23 passed by this court, my lord, that is writ petition number 5424. Item number 13, my lord.
18/9.
18/9/23, the first order passed by this court, whereby my transfer order was stayed, my lord.
Yes.
18/9/23, my lord.
Yeah.
Second page, my lord. Next page, my lord. Paragraph 3, my lord.
Yes.
As the authority in BVFC Namrup tried to enforce the memo dated so and so, issued by the chief personal officer upon the petitioner, the present petitioner earlier preferred a writ petition being so and so, which was settled between the parties on compromise, due to which the petitioner preferred an interlocutory application being IN number so and so in the said writ petition, and that was disposed on 23/9/21, allowing the petitioner to withdraw the said case number so and so, and accordingly disposed of on being withdrawn by order dated so and so. It's in the year 23. Next paragraph, 4. Thereafter, respondent in BVFCL Namrup once again tried to enforce the said memorandum dated 31/08/2019 noted above, for which petitioner had to prefer a writ petition being so and so against the respondent authorities, BVFCL, that is item number 14. After considering the materials and findings, the issues involved in the earlier WPC so and so instituted by the petitioner, disposed of on 23/9 so and so, the court on 16/6/23 in WPC number 3452, item number 14, my lord, while issuing notice to the respondents so and so, in the interim directed the respondent in the BVFCL not to initiate any coercive action against the petitioner on the basis of the said memorandum dated so and so. While the said WPC is pending for adjudication, the Deputy General Manager, my lord, the respondent number 5, by the impugned order of his reference number so and so, transferred the petitioner from BVFCL Namrup to the marketing office at Bhubaneswar, Orissa, without specifying the postman. This is the most important thing, my lord. I was transferred to a place, to an office, my lord. No post has been assigned to me. Now, next paragraph, my lord, being agreed with the same, the petitioner had preferred this present writ petition, challenging the said order of transfer to so and so from so and so, my lord. And in the interim, my lord, it was stayed, my lord. Now, your lordship will find that the impugned transfer order, my lord, at page 55.
Yes.
For administrative convenience and smooth functioning of marketing department, the following arrangement has been made with immediate effect. Sri Osim Kumar Datta, Deputy General Manager Marketing, so and so, is hereby transferred from Marketing Office Namrup to Marketing Office Bhubaneswar, and he will be responsible for imports of urea, port handling, bagging of materials, and other work assigned by the management on time to time. Sri Osim Kumar Datta will continue to report to the General Manager Marketing. Well, this is the order which is under challenge, my lord. Well, this order I challenge, my lord, on the ground, my lord. First of all, my lord, as I had preferred a repetition before this court, my lord, which was state, my lord, whereby a direction was given, no coercive action should be taken. My lord, this transfer order is issued as a punitive measure, my lord. My first submission, my lord. Secondly, my lord, I have been transferred to Bhubaneswar, my lord, to which post I am transferred, my lord. There is no mention in the transfer order to which post I will go there, my lord, in which post I will be there, my lord.
Prior to this order,
My lord.
you had come before the court.
Yes, my lord. That is item number 14.
Okay. Challenging what?
Challenging a memorandum whereby they have asked me to produce all the original documents, the companies which I have worked earlier joining this from the fertilizer company. In that case also, I have submitted all the documents except one company, and that company is no more in India, man. That's why I cannot obtain the release order of that company. And that was, in that case, no coercive action was to be taken, when that direction was there. And immediately after I have obtained this order from this court, immediately they have issued a transfer order transferring me from Namrup to Bhubaneswar without assigning any post.
No, the post is there.
No, my
Marketing
lord.
office.
My lord, should we see page 55, my lord, to which post, my lord?
Yeah.
1 second, my lord, I'm reading, my lord.
Down.
There is no mention about the post now.
Yes, okay.
And the post which is held by the officer in Bhubaneswar, my lord, is a person, my lord, who is, my lord, 5 ranks below to me, my lord. And he is the, my lord, deputy manager, my lord. He who is 5 ranks below to me, my lord. And from inception of that office in Bhubaneswar, my lord, till date, my lord, no.
No, but how do you know that the person who is in whose post you are placed when the post is not mentioned?
Yes, because I know, because the person who is presently holding that post, my lord, is a, my lord, deputy manager.
So
But
you have been downgraded.
Yes, my lord. If I am allowed to go and hold the post there, well, that is a post which is ranked below, well, 5 ranks below to me, my lord. And thereafter, my lord, one more, my lord, that part, my lord, I want to bring into record, my lord, as because, my lord, that if whether that post has been held by a person who is 5 ranks below to me, my lord. Because they have filed also affidavit, my lord, they are silent to their effect, my lord. Well, what my yesterday I called up the client, my lord. Well, I think I'll bring on record, my lord, whether that post, my lord, from the date of inception of that office, my lord, till now, my lord, that post is held by a person, the rank of deputy manager. And I am, my lord, right now, my lord, deputy general manager marketing. That is one aspect, my lord. And secondly, my lord, they have filed an affidavit in this case, annexing one office memorandum of their own matter, whereby they stated, my lord, it says, my lord, a person can be transferred after a period of 3 years. So a person is allowed to hold a post, my lord, in a particular place for at least 3 years, my lord. In the instant case, my lord, I was transferred, my lord, on 23/9/23. Sorry, 23/11/23 from Guwahati to Namrup. But within a span of 1 year, my lord, they again transferred me to, my lord, Bhubaneswar. Their affidavit, they say so, my lord. And moreover, my lord, last thing is that, my lord, I'm going to retire by this end of this year, my lord. My lord, December is the last month.
First thing is, What is the post in which you are transferred?
Yes.
Is it downgrading?
No,
That's
absolutely false statement.
No, no,
But he is.
that word should not be used,
Let
but with all respect,
let-
false,
let him-
false
let-
word should not
false,
be.
absolutely
No,
false.
man.
I'm insisting.
below.
It is given below also, Akim Datta, Deputy General Manager Marketing.
No, he is Deputy General Manager Marketing.
Yes.
No,
We are not downgrading the post, we've clarified in the affidavit also, he remains in the same post. In fact, he is going to
so
a better.
why is it not mentioned in the order?
You know, there is some defect in the order maybe, but that cannot be disputed as being something against. We are giving him the benefits, he's continuing to remain.
Normally when a person is transferred, he's
Yes.
transferred from X post
No, I have
and mentioned
questioned,
that he is posted and Y at such and such.
I have questioned my client on that also. It's absolutely inadvertence. There's no problem there. He's aware also. He's not downgraded.
Mr. Toto submits that he like
It
bring
suits him. It suits him.
he's submitting that he's got instructions to say that this post in which the petitioner is being transferred has been consistently manned by people in the
That is wrong. No, absolutely wrong. There are people who are there who are lower to him in rank. He is not posted below them. He's been directed to, he has been immediately said,
marketing office.
Marketing.
but he will continue to report to the general manager
It's a
marketing.
small office, my lord. It's a only one
No,
group, my lord.
we are trying to expand that office. Bhubaneswar is supposed to become a big terminal.
But to that effect, I want to
No,
bring on record.
that is a different issue.
And you
Now,
don't-
now see, in the second paragraph,
Yes.
kindly read the following responsibilities handled by so and so will be handed over to so and so acting DGM. So therefore, the person the petitioner was holding charge.
That is in Namru.
That is for Namru.
That's right. So he was in Namru.
Yes.
He was a DGM.
DGM.
So his charges are now being handled by another DGM
In Namru.
in Namru.
He is transferred to
But
Bhubaneswar.
when you transfer him,
Yes.
you transfer him to the marketing office and tell him that he will report to the general manager. But as what?
He is in a higher rank. In fact, more responsibilities are being
So
given
that
to him.
needs to be clarified by your
That
office.
We've done that ultimately in the affidavit we've given. But now he is choosing not to go there. Simple as that.
Maybe that is a different issue, but
That's the, my lord, I want to bring on record, my lord. From the inception of that office, my lord, all along the post has been held by a junior person, my lord. Like, with record, I can file an affidavit to that effect, my
Office
lord.
is not static.
That may be, but
no, it need not be static. It is possible that the same nature of work may be handled by someone junior or someone senior. But a person is entitled to know how is he transferred and what he is going to join as what.
We've given details, we've given in an affidavit, he is not responding to that.
No, but your affidavit will not supplement an order of the.
It's a clarification on oath. Absolutely clear. We have not downgraded him and he is supposed to handle more responsibilities. Everything is given.
he should be happy.
Everything is responsibility. In fact, there was no stay order initially. It's just that no coercive measure according to him. And what is it coercive? What does it say?
Where in the affidavit, which paragraph have you clarified?
28, page 7, paragraph
Page 70 of our affidavit. Paragraph 28. Maybe
Yes.
that while denying the correctness of the averments made in paragraph 25 of the petition, the claim of the petitioner that the assignment given to the petitioner is much lower in grade than the post which is presently held by the petitioner is categorically denied. The petitioner is transferred in the same capacity as the Deputy General Manager Marketing of the corporation, which is clearly evident from the said office order.
And he has been assigned the responsibility for all imports of urea, port handling, baggage. bagging of-
Why don't you issue a corrigendum to that effect? Doesn't the office issue a corrigendum?
You can do that also. You can do that. It's clarified here. He has not denied it.
See, there'll be a time when you'll retire from office. There'll be a time somebody will calculate what pension or what benefits he'll get. Now that authority may or may not rely on your affidavit. They will rely on the orders available in the record. The order in the record does not clearly say what post he is joined.
Even in the order that was given to him,
Right.
It's been addressed to him as Hashim Kumar Daftar, Deputy General Manager Marketing. Below. Not in a lower post. Down below. Just below. End of the office order.
No, that's right. But this is issued to the person while he's posted in Namrup. So in Namrup, he's still Deputy General Manager Marketing. Yes, sir. Same thing. Otherwise, same thing. Anyway, you see if a corrigendum can.
Yes, we can
settle
definitely.
the discrepancy.
I'm
Meanwhile-
grateful to your lordship for pointing
Meanwhile,
out.
the counsel for the petitioner wants to bring out record.
Yes, madam. Fine.
They're saying that this is meant by consistently by junior people. If that be so, hypothetically, if that be so, then you have to explain why or.
No, if your lordship reads my affidavit, it's absolutely clear.
And it's 30
What responsibility administrative to be given to him.
I have
And
denied that fact, my
How
lord,
long
but-
will you take to file the affidavit?
My lord, at least 10 days, my lord, a week's time, my lord, because he has to come from Namrup, my lord. A week's time, my lord, a week's time. maybe.
Interim order be vacated, because even that so-called coercive measure which is.
No, my
Acting
learned senior friend is misleading,
Interim order is
my
with
lord,
regard to
I
the
think भूल है, sir.
transfer order. The transfer order is stayed.
Stay, transporter stays, दादा, भूल है आपने. Now, very first day it was stayed.
Transporter to stay.
Coercive measure is with respect to certain documents you are supposed to file as per his service conditions, which he has not done till today.
That is in the other writ.
Other petition.
So let him file that affidavit. Let him file it within 10 days or
10 days.
In the meantime, we may give the corrigendum.
you can issue the corrigendum. There is no bar issuance of the corrigendum.
No, that may be made regardless, that is also provided.
Or you get your instructions, we will take a call on the next thing. Because the primary order is under stay. So is an issuance of a corrigendum will not you can issue a corrigendum. We are just making an inquiry why a corrigendum was not issued.
What is the that's my mistake in not guiding them.
No. You can't guide them for every
No.
order that is to be passed by the authority. Right. Mr. N.J. Dr. Learned Counsel for the petitioner submits that there are certain additional facts you'd like to bring it on record by filing an additional affidavit. He prays for some time. Mr. M.Z. Ahmed, Learned Senior Counsel, assisted by Mr. Dr. On the other end, submits that there is an urgency in the matter as an interim order is continuing and the petitioner is not joining in his place of posting in Bhubaneswar. Therefore, the attempt be made to dispose of the matter on the date fixed. Accordingly, let the matter be listed again on '28. We can have it on 28.
16, 20, 28, my lord. I am obliged, my lord.
28 will be far.
21st.
Can be 21st.
21st.
Request it.
All right, 21st.
In meantime, we may be permitted
That,
to issue the
stay-
corrigendum.
Stays
No. Issuance, you may issue the corrigendum, but that by itself will not Vacate will be considered to be the interim order to be vacated because the primary order is under.
We have another big
Ah.
problem going on because of that particular stay order. The petitioner is neither here nor there. He is staying in Namrup, evading all the facilities, not doing a single bit of work in spite of being requested to.
Let them bring on record, my lord, by filing an affidavit, that part. He's not.
I can bring
Yes,
it on
you bring it to
record.
record. You bring it to record, I'll give a reply that way.
I'm not wanting to be vindictive, but this is what is
You
happening.
bring it to record, I'll give reply.
He refuses, he hangs around the office premises, refuses to
Well,
do anything.
in both the cases, my lord, interim
cases
order
pending.
running, my lord, that may be,
All right.
interim may be continued.
List on 21st.
The interim order.
Interim order passed.
Both.
Continue.
Both cases.
Both the matters.
I'm deeply obliged.
In the event is not taken up on the day, at least interim matter.
Sorry.
In the event the case cannot be heard on that day, at least the interim matter.
We'll attempt to dispose of, subject to the parties being available and pleadings completed.
Kindly pass over the matter for the day.
Why?
Should,
For the petitioner.
yes.
Learned Counsel, MS Bodoloi submits the writ petition. Matter be passed over for the day. List next week. Mr. B. Sharma appears for the accountant.
May I please, Lordship? Lordship, here in the case the petitioner is a SS officer on certain allegations, he was suspended on 9/2/2023. And subsequent stage, my lord, there are 4 extensions were made in respect of, my lord, this suspension order. And the first question that required to be dealt with, that is the review which has required to be done on the law that has not been properly followed up. Number 1. Number 2, my lord, the issue pertaining to is that, my lord, in terms of Ajay Chaudhry's case, paragraph 14, my lord, the charge has to be framed under, my lord, within period of, my lord, 30 days, 90 days, that has also not been followed. And apart from, my lord, the departmental, my lord, the procedure also indicate that 2.1.8 manual of departmental procedure, my lord, that the charge, if not be framed within 90 days, my lord, the suspension order cannot be sustainable. Now, Lordship, can you see the last order passed by this honorable court, which is very pertinent? 7/3/2024. Seven 3/2024, the direction passed by this honorable court to the effect, Mr. Nath, learned as senior government advocate, will apply this court as to the status of the inquiry proceeding initiated against the writ petitioner, filed the so-called notice dated 9/2/2023, and or as to the last review order reviewing the continuance of the suspension of the writ petition. There are 2 conditions that has been given. Now, Lordship, pursuant to that affidavit was filed by them, Lordship, kindly look, they're totally silent that both has not been complied with the action. Neither that review order has been annexed herewith, nor, my lord, the status of the inquiry proceeding that has been given. But, Lordship, in the meanwhile, we have just came to know that an inquiry officer was appointed in the month of February, my lord. Thereafter, my lord, no charge has been framed, nothing has been done. My lord. It's a straight case, my lord, since charge has not been framed, my lord, till date. I'm entitled to reinstate it, my lord.
Yes. What about the appeal?
Lord,
There is a
appeal, my lord,
statutory
yes,
remedy.
my lord,
having an
yes,
appeal.
my lord, that is a pertinent question. My lord, here is a case, my lord, if you see the schedule, my lord, the appointing authority is my governor, and appellate authority is also the governor, my lord, in case of, my lord, this legal case is there. But anyway, my lord, here is a case, my lord, that if suppose then, my lord, they want to carry out the departmental posting, let them care, but I should be reinstated, my lord, because, my lord, more than 1 year has elapsed, my lord. Ultimately, they are harassing us, my lord.
No, no, my lord, possibly it is not correct that after appointment of the inquiry officer, charge will be framed. Charge has been framed departmental proceeding after that, the inquiry officer has been appointed in the month of February 2024. Lord, kindly come to serial number 4. I'm indicating what. The disciplinary authority does, under provisions of Rule 9 of the Assam Civil Services Disciplinary Appeal Rules 1964, appointed an inquiry officer by order number so and so dated 20th of February 2024 to inquire into the charges framed in the departmental proceeding drawn up against her. Therefore, it may be mentioned that the disciplinary proceeding drawn up against so and so is at inquiry stage, and the inquiry report is awaited. That is as regard the inquiry report, status of the inquiry. And their lordship will find 19 to with effect from 9th of February 2023, the suspension has been extended. That order is there. It is there. Kindly see serial number 2 in the letter.
Serial number
2 in that letter. That letter I have given 13th of March letter. Serial number 1, 2, 3, serial number 2. No, this is my instruction.
No, nothing is on record, my lord.
No, in the affidavit we have filed, no? Yeah. Or in the branch, kindly see in that letter there are annexed.
Yes.
Kindly see the third page.
Third page.
19th of February 2024. This is the last. This is the last extension order. 19th of February has got to go.
What are the parameters for interference or
My lord,
suspension?
But there, lordship, normally, my lord, in such a situation, the first thing is that suppose the procedure which required to be followed, it had not been followed, my lord. It is a separate thing, my lord.
Suspension is pending disciplinary proceeding.
Exactly,
no
my lord.
other procedure
No,
prescribed.
no doubt, my lord. Question is that, my lord, suppose if the review has not been conducted in terms of, my lord, the procedure to be followed, my lord, then, my lord, lordship may interfere there with number one. Number two, my lord, kindly see that this is the settled position of law. That in terms of service law, that within 90 days, charge has to be framed. And if you look into, my lord, that Ajay Chaudhary's case, my lord, paragraph 14, it clearly mentioned that within 90 days, my lord, charge to otherwise, my lord, no suspension order can be.
Well, you must read para 22 also.
My lord.
In that case, after para 21, you must read para 22 also.
My lord, the Ajay Chaudhary's case, my lord, if lordship permits me, may I place the judgment, my lord?
You read para 22.
My lord, here is, my lord, paragraph 14 are there. Last paragraph is 14, my lord. If don't mind. Suspension can be extended otherwise, my lord, but question is that, my lord, can you see paragraph 14?
Oh, this is not an SCC.
My lord, exactly understood, lordship. Anyway, my lord, thing
Then
is
you
that.
read para 15.
Yes, ma'am. So far as the facts of the present case are concerned, the appellant has now been served with a charge sheet, and therefore these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continuous suspension in any manner known to law, and this action of the respondent will be subject to the judicial review. Question is that, my lord, that is the thing that charge required to be framed, which they have not framed just now, lordship. It is otherwise not the part of record. They want to say that inquiry officer has been. Nothing. Affidavit doesn't say about framing of charge. This just say about inquiry officer appointment, my lord.
Appointment of inquiry
Even that is
officer
also not the part of affidavit.
Appointment of inquiry officer is always after the charge, my lord.
No. You are issuing a show cause.
No. Well, let me please, show cause is issued. She has inspected all the records we have said, and
then she has given a reply.
Being dissatisfied with that, they have decided to go ahead with the inquiry. Then, my lord, inquiry officer is appointed. Inquiry officer is not going to frame the charge. After framing of charge, that we have taken a decision that yes, we want to go for a disciplinary proceeding. Then only, my lord, the inquiry officer will be appointed.
But where is the charge, my lord? We have not received any such kind of charge.
Where is the show cause?
Petitioner has petitioner.
Is the show cause available here?
Yes, my lord. Show cause is there, my lord. Read petition.
I have the record, my lord.
Read petition.
It is the submission of the petitioner that on 19th to the inquiry officer has been appointed. My lord, this is the charge.
My lord, page
I have the record.
82.
Page?
82 of the read petition. Last more than 1 year, they're sitting silent over the issues, my lord. Page 82, elect the slip.
So the statement of allegations, everything.
My lord, exactly. You are hereby to show cause, my lord. This is the only show cause notice issued under Rule 9 of the Assam Service Discipline 1964, where, my lord, they have mentioned that thing of.
So what is the charge sheet?
Nothing, my lord. We have not.
What is the charge sheet
That
according?
is the show cause notice. My lord. That is it.
Are you asking for a separate charge sheet to be framed?
My lord, show cause notice issue we have replied. Suppose they may satisfy. Otherwise, my lord, they may frame a, my lord, separate charge, my lord.
Show cause notice is with regard to the following charges.
My lord.
Against you, accompanied by statement of allegation.
My lord.
And the list of witnesses and so forth.
Yes, my lord. Allegations they have given, my lord. Now, list of witnesses, etc. Afterward, my lord, we have submit our reply. Pursuant to that, my lord, they have appointed inquiry officer. Now, till that, my lord, nothing has been done, my lord, since the officer which has been appointed in the month of February.
So,
now,
therefore, what is the ground for
exactly, my lord. Lordship, kindly see
the suspension?
quite right, my lord. Lordship, they have made a submission that the last suspension order which was extended in their affidavit, Lordship, kindly see for a moment.
19 February.
Yes. Now, 19 February, suppose this is the extension order which they have made, my lord. Question is that, my lord, this honorable court clearly mentioned prior to that the which was extension order was passed, what was their review order? They have failed to produce, my lord. It creates a doubt that there is no review prior to that. Number two, so far this 19 February 2014 order is concerned where extension is made.
What's the law regarding judicial review of suspension order?
My lord, lordship already on last occasion while this, my lord, matter was dealt with, then that's why lordship on last order it was reflected in its order saying that they have to place the status of the inquiry
What is the law for judicial review? That is what I am asking you. Show us some law, show us some precedent that in given conditions, how suspension orders are to be decided by a court under Article 23. Give us some precedent. Give us some law. You are urging on the fact that suspension, then first review there is no record. Second review they have a record. By this time they say that show cause notice, etc., etc. So therefore, relying on Ajay Chaudhary, since it was not done before 90 days, should be set aside. That's your case.
Yes, sir, that is my.
Now, here is a case where, assuming there are judgments to say that notwithstanding that it is not done in 90 days, we may still decline to interfere. But besides that, what is the parameter for interference of suspension?
My lord, prima facie, my lord, lordship, I place the precedent, my lord, there is not, my lord, I will look into that.
But show us the law.
Right.
But show us the law. Show us the law.
My lord. Then lordship may kindly fix it next week, my lord, I will place it. My lord, otherwise, my lord, what thing they are doing, my lord, ultimately their whole intention.
That is why we are repeatedly asking you to show us the law. What is the law under which we can go for judicial review? Whether these parameters have been satisfied. Please next week, at the request of learned counsel for the petitioner. Mr. D. Nath appears for the respondents. Records call for be kept for perusal of the court if the need arises.
Second May, my lord. Thursday.
Second May.
Kindly.
Second May, all right. List on second May.
Lordship, in item number 17, Lordship, we are seeking a short accommodation, Lordship. I have informed the counsel for the other side also, Lordship. So the matter may be taken up after 2 weeks.
After?
2 weeks, Lordship.
For date may be fixed.
No, we can't fix a date. Hearing matters will come on part 2 list. Matter be adjourned for 2 weeks at the request of learned standing counsel Finance Department.
Health Department.
Health Department. Consent has also been, the prayer made is not objected to by the learned counsel. List after 2 weeks. Can't fix a date like this because it's not repeating. Once we fix a date, don't agree for an adjournment. You have agreed for an adjournment. To inform Lordship. Whatever, you have agreed. What is the point in fixing a date?
But later I have placed, I'll take that.
Yes, please.
Lordship. All of
Yes.
My lord, these are those series matters, my lord, pertaining to eviction, my lord, from the part and parcel of land which belong to, my lord,
Medical college.
medical college, TB hospital. Now, my lord, it is nomenclatured as second medical college. Now, my lord, during the proceedings of the present batch of petition, certain subsequent developments have taken place. And we have, my lord, brought those developments on record by way of filing additional affidavits. But, my lord, while filing the additional affidavit, we have found, my lord, that some error has crept in with regard to certain communications, my lord, which was furnished by the circle officer to the office of the deputy commissioner. So under those circumstances, my lord, we are craving the leave, gracious leave of this honorable court to file a, my lord, another additional affidavit by issuing a corrigendum to those communications, because that needs to be done.
That earlier affidavit is filed.
Yes, it is filed. Now, Lordship will kindly mark here, my lord, the matters where, my lord, we are now required to file further affidavit. My lord, that is with regard to item number 20. Item number 20. Then, my lord, item number 21, item number 22, and item number 53. So in these four matters, my lord, we are required to file a further additional affidavit, bringing on record, of course, my lord, the corrigendum. Some
Who's
typographical error.
Who's
because
appearing for in this matter?
Number 20,
20, 21, 22, 53.
yes, 20, 20, 22.
And my lord, 53.
Yes,
21 and
21 I am
53. 21, I am appearing. 53, item 53.
53 also.
You heard learned counsel, Mr. R. Porputari, Revenue.
Revenue, my lord.
Submit that certain errors have crept in the additional affidavit, in certain documents, that entail the additional affidavit filed earlier. And in that context, he craves leave of the court to file a further additional affidavit, bringing on record the corrigendum showing the corrigendums correcting the errors that had earlier crept in. These affidavits are to be filed in, if they receive the numbers, in item numbers 20, 21, 22,
and 53, my lord.
There are learned counsel, Mr. P. Sinha, Mr. R. Muzumdar, appearing in his petition, do not object to the prayer fee. Let the affidavit be filed within.
My lord, within 2 weeks we will file it.
Within the matters be listed there. Any other counsel, any submission? Matters be listed after 2 weeks.
My lord, with all humility, may I pray for a date, my lord? After 14, my lord, 13 or 14, my lord, can it be on 14? If it is not inconvenient.
Not 14, just to 21st.
21st of May, my lord. I'm so obliged. I'm so
on 21st.
They are already protected in the interim.
They are not worried. Why are you worried?
I'm so obliged.
This is the revision of pay, my lord.
It is directed to be listed in the next hearing list by the last order.
That we have actually matter for that. We had mentioned earlier, my lord, for this.
We have already passed the order. It will be listed in the hearing list. Let it be in the hearing list. You have liberty to upgrade.
Then I will update. Then lordship may be any date may be fixed. my lord.
No date. It will come in the part 2 list.
Correct.
We are trying to put all matters in the part 2 list.
My lord.
And on any date where time is available, councils are entitled to make a mention for upgrading. We take a matter.
I leave it to you.
Otherwise, if we fix a matter today and if it goes out of the list, another
Then-
date is to be fixed.
Right,
So we do not know what will be the position there.
right, right. And today it is not possible to.
And some days we find that on miscellaneous day also, the list is over by 3:30. We have
Right.
an hour or so left. We could have taken up hearing matter.
Then we will try our luck, my lord.
You take a chance. Your luck is always there.
Yeah, my lord.
As per the earlier order dated 21/7/2023, the matter was directed to be listed next hearing. Accordingly, the registry will ensure the matter to be listed for hearing in the next part available part 2 hearing. As and when the matter is listed, as and when the matter listed in the part list, the learned councils are at liberty to make a matter to the court. Okay.
Develop.
Mr. Borpuzari, Mr. Thor, Mr. Sharma, Mr. Munir, respective councils appear for the respondents.
Obliged. I'm obliged.
55 is already adjourned. You don't want to do 55.
No, Lord, now I'm here. I will do lordship because I will do lordship. Actually lordship. Initially, I was ready to do this matter, but since I was not feeling well in
If you're
second
not
part,
feeling well, we'll adjourn it, we'll fix a date.
because this is a pension matter, lordship. That's why a date may be fixed, lordship.
Pension should not give you tension. We will take up the matter on some other day.
Lordship, a date may be
Item
fixed, lordship.
55, learned council for the submit the matter be listed next week.
Next week, lordship. Any date fixed, lordship. At for convenience
Nine.
of the lordship.
Not next week, instead of 9.
Deeply operated.
Hearing this, item 10. Yes, anyone for the petitioner? What is the prayer here? Lesser salary, lesser pay.
They're looking for counting the non-gazetted period for calculation of the pay.
Okay, none appears when the matter is for the petitioner when the matter is called up. Mr.
R.B. Goswami.
R.B. Goswami appears for the IWP.
IWP.
Call up again. Next. Or exactly. Yes.
My lord, it may be taken up some other day.
Item 11 at the joint request matter be called up next week.
So I'm appearing for Oil India Limited on behalf of the Asia.
For oil.
Oil India Limited.
Any control